All right. Hello, everybody, and welcome back to Raw Law Unfiltered with your host, the DUI Guy Plus. Today, we are having a very special stream for multiple reasons. Hopefully, the sound is good, the video is good, and you all can see and hear me. I've been trying to fix this, whatever issue I've been having, for the last literally 10 minutes. I was ready to go at 2 and then my microphone decided to crap out on me. So anyway, this is a very special stream for 2, if not 3 reasons. Number 1, this has pretty much been like a whole month in the making, okay? YouTube reached out to me, I think at the end of like October, maybe beginning of November. So we've been working on this. There were several streams, at least one, planned before this one. And sound is low. Here, I can turn it up a little bit if this is going to be better. Let me know if this is better. The thing, this has been in the making for like the longest time. And I'm very gracious to YouTube for allowing me this opportunity. I think it's pretty fucking cool, not gonna lie. The fact that there's this new feature, okay? There's this new feature that they are trying to roll out. And that is, as you can see, if you look to the top left of your screen, right over here, right about here, you should see a pinned product. Okay, this is something that they're trying out. It's a product that you showcase while you are live. And there are also products pinned there, because this is live at this moment, unless you're watching this as the replay crew. Hello, replay crew. How you doing? If you're not replay crew, you should look down and you'll be able to see right underneath this window some products, non-pinned products that I've selected. And one of those products is one that I am wearing right now. That is a t-shirt. It says, "You lost," Johnny's head on it, holding a mega pint, and he says, "Here, have a mega pint." I just thought that was brilliant. The YouTube designer team place thing or whatever designed it, and I think it's absolutely fucking brilliant. They also have that same thing on a mug, on a pint glass, and a mug. So all of those are available if you click on the link where the pinned product is, or below, or I will include it in the description as well. So you'll have plenty of places to be able to access the merchandise, if you so wish, if you so desire. I think it's really cool. I think it's cool that YouTube decided to use me as their guinea pig. And I think that hopefully this is something that is going to be rolled out in the future. You know, that many more content creators can showcase their products and use the YouTube platform in an interactive basis. Like, let's say you are rolling out some new merch, rather than just talking about it and putting a link. Well, there it is, you guys. You can be like, look, there is my merch. And you can pin one product, and I think you can like roll it. I don't know. This is a brand new feature. Absolutely brand spanking new. Like I said, it's in beta. They're testing it. I'm being used as a guinea pig for it. So go get the shirt. Go get the mega pint glass. The pint glass with the mega pint Johnny on it. I think it's brilliant. I think it's cool. I think it's sexy. I think it's fun. Xenia is right underneath me asking for attention. You want to come up? You want to sit? No, she's like, okay, I'm going to run away. She ran away. She just wanted to claw at my... she wanted to claw at my pants. So anyway, we are gathered here today for a very special occasion. as you all know. So that was special news number one. I know I kept this under wraps. I kept this a secret. I tried to keep it as long as I could until the very last moment. And yeah. Number two, we are gathered here today to review a very, very special brief. So if you all remember, on November 3rd, Johnny filed his brief in his appeal. And remember, there are two appeals happening, right? There are two appeals that are running right parallel to each other. You have Johnny's appeal of the one count that Johnny lost and the jury found him liable for, the Depp Waldman statement that Amber won the $2 million on. And then Amber is filing her appeal, and she's appealing all three counts that she lost on, and she's appealing the $10.35 million judgment. Well, today we are going back to Johnny's appeal and Amber's response to Johnny's appeal. Okay, so when Johnny filed his brief on the 3rd of November, hers was due on Friday. It was submitted after hours, and thank you, shout out to Laura Bokov, who got it slightly ahead of me. She always seems to be right on top of the money. I think I beat her one time. I was able to beat her one time, and it's not a competition. It really isn't. But like, I get more stuff, but she gets it faster. It's kind of weird. We have a very good relationship because I fill in the gaps that she is missing, and she just gets the stuff like ahead of me. So when she gets it, she shares it with me, and then when I get all the fill in the blanks, I share them with her. So we have a very, very fun relationship in that sense. So don't forget to like this video, comment below, subscribe to the channel if you haven't already. Welcome to the channel, Susan Forbes and a few others. I apologize if I had missed any. I know there were some people who joined while this was not even live yet, so I do apologize. Your message disappeared, but I'm shouting out right now. Thank you for joining. Okay, here it is. Here it is in all its glory. In the Court of Appeals of Virginia, of course, we have the record number. Now remember, the parties are flipped. Again, the parties are flipped. We are looking at Johnny as the plaintiff. It's not called plaintiff. It's called appellant in the Court of Appeals. He's the appellant, and Amber Laura Heard as the appellee because she's the one who is answering the appeal. This is the brief of the appellee. See, this word matches this word, which means this is the person that wrote this document. Now notice something very interesting right out of the gate. Something very curious, very unusual, that I did not expect to see. If y'all remember, it was Amber hired Ballard Spahr, the notorious First Amendment team, to represent her in the appeal. Well, first thing you'll notice is, where are they? Their names are not mentioned anywhere in this brief. And by the way, for those of you who want a copy of it, because I obtained it from Laura, who obtained it from the Court of Appeals, I'm going to let her send you all the links. She usually links these on the channel, on her Twitter page. So I'm going to give her precedence because she obtained it. I think it's only fair. I want her to be the one to divulge the link. So I am not going to do it. I may do it after she does it, but I just feel it's only fair. She's the one who obtained it, so she's the one who's gonna get a chance to disseminate it, if you will. So I love her, and I like to give her respect. So Mr. Rottenborn is the only one. I mean, Elaine McCafferty, sure. He's the only one who appears here, basically. Woods Rogers Van Deventer, Black PLC, the law firm that has represented her in the trial phase, is the only firm that is being mentioned as the firm who helped her respond to Johnny's appeal. Now that raises a couple of interesting questions, okay? Question number one, did Ballard Spahr decide to butt out of this? Did Ballard Spahr, she could not afford Ballard Spahr? Is it possible that she simply didn't think that this is as important? I don't know. Did she think that Ben Rottenborn can do a good enough job? I don't know. There's lots and lots of questions and absolutely no freaking answers. Beautifully Damaged, thank you. She says, I'm a little late. You're not that late. We haven't even started getting into the juice of the brief yet. See, people are saying, like, she probably couldn't afford them. She probably couldn't pay them. It isn't a lot of extra expense. And if she can't afford it, she's going to skip over it. And she's going to get mediocre representation. No offense, Ben Rottenborn. Actually, all offense intended. But anyway, as always, we start with the table of contents. This does not count towards the page count. We have the table of authorities, and immediately we're going to dive into the statement of the case, and then the statement of the facts. Notice how, even though this is a defamation case, we constantly and nauseatingly have references to the abuse, which has absolutely nothing to do with defamation. I find it unprecedented, really. If there was like a question of, did, he abuse her or did she abuse him as part of the allegations, if it was like a criminal case, right? Or a family law case, I could understand why, but you keep bringing it up. It shows that you have you're lacking in legal argumentation severely. So you have to constantly appeal to emotion, and that is not a good look for an appellate lawyer. And is actually a terrible look for an appellate lawyer. You do not want to appeal to emotion. Why? Because judges don't give a shit. Judges don't care about emotion. All they care about is your legal arguments and your legal justification. Now remember Johnny's argument, right? The Depp-Waldman statement had nothing to do with Johnny. That's literally their entire argument. That's their brief in one sentence. Johnny didn't say it. Waldman said it. Waldman was not a party. Then what the heck are we doing? Right? Statement of the case. The abuse on May 21st, 2016. Mr. Depp's intent to retaliate against Ms. Heard. Mr. Depp's and Mr. Waldman's relationship. Now this is probably going to be important. Mr. Depp's motion for summary judgment and motions to strike the evidence. The refused jury instructions on independent contractors. And then we dive into the argument. Their first argument on response to Johnny's arguments. Mr. Depp's independent contractor theory is inappropriate, and whether Mr. Waldman is his agent was a question of fact. So not a question of law is going to be the argument. The jury has decided rightfully in Amber Heard's decision. And they're going to go through it. Standard of review. Mr. Waldman can be both an independent contractor and an agent. The circuit court properly denied the motion to strike because whether Mr. Waldman made the statement while acting as Mr. Depp's agent was a question of fact, not a question of law. The court need not adopt any rule regarding whether attorneys are independent contractors as a matter of law. That's argument number one. What is going to be their argument number two? Ms. Heard presented sufficient evidence of actual malice. Mr. Depp waived any argument that summary judgment should have been granted. Here's the standard of review. And Ms. Heard could prove defamation by showing either Mr. Depp or Mr. Waldman had actual malice. Now, this is going to be interesting to see the legal argument on because this seems very, very unusual that you can prove defamation through the words of another that is not even a party to the suit. But we'll see. We'll see. I'm looking forward to reading that one. This statement is actionable because it contains a provably false factual connotation relating to assignment of error 1C. Here is the standard of review, and the statement is not protected speech. The circuit court correctly rejected the proposed jury instructions on independent contractors. This is argument number 4. Standard of review, jury instruction fully and fairly covered the principles of agency. And 5, the circuit court did not abuse its discretion by requiring redaction of irrelevant and inadmissible portions of the article containing the statement. Here's a standard of review, and the redacted portions of the article were inadmissible. Conclusion, certificate. So just as before, right? No surprises here. This is going to be the outline of all the arguments that are going to be made. We start with the cases. This one should be pretty case heavy. There's page 1, page 2, page 3, page 4. Statutes, other authorities. Notice there's not a single cite to an outside source. And I'm not going to lie, I actually kind of like that. I really, really like that. I like the fact that there's case law, Virginia Code, and restatement third of agency, because we have an agency issue here, whether or not Mr. Waldman was an agent speaking on behalf of Mr. Depp and whether it extrapolates to Depp himself. And a bunch of cases, mostly from Virginia. There's some from New York, I see, Utah, United States Supreme Court. That's how you write a brief. See, for the first time, leave it to Rottenborn to do a good job for once. Because there's, look, this is where normally, right here, in this blank space after the other authorities, this is where they would fill in the, in this article, and you heard about the Bot Sentinel article, and you heard about this article, and you heard about that article that says this. Judges don't care about articles. Judges care about the law. And this one is fairly straightforward in the sense of agency is the number one end-all and be-all question. Can Waldman's statement be extrapolated to Depp? Yes or no? And Johnny says yes. Johnny says no, it cannot. Amber says yes, it can. And their lawyers are doing the talking for them, of course. So, statement of the case. During the course of their relationship, appellant John C. Depp II, Mr. Depp, abused his wife, appellee Amber Laura Heard, right out of the gate. Again, manipulation of the facts. The jury did not find this. This is blatant misrepresentation of the facts, of the law. It's misrepresenting what happened at trial. It's frustrating, but it is what it is. They're going to write it. They're going to write it. Physically, verbally, emotionally, psychologically. Notice once again they dropped off sexually. Wasn't that the whole scenario with the bottle that they were talking about at the trial? Ooh, ooga booga. I have no evidence, no proof, no doctor records, no notes, no photographs, no nothing. But he did it, I swear. I never went to the doctor after being brutally assaulted like that, allegedly. It's nonsense. That's why they dropped it. They realized the most gruesome acts that she alleged that Johnny did, they literally dropped them off the face of the earth like they never happened. That's how you know that they were fake. Because that would always be front and center. Literally, that is the biggest thing that she alleged. And the fact that her lawyers are like, yeah, I'm not touching that with a 20-foot pole, lady. As Johnny would say, you lost. Here, have a mega pint. Mr. Depp promised her that if she ever left him, he would make her think of him every single day by ruining her career and her life. Okay. After she obtained a protective order against him, that sounds more like Amber, by the way. I think that if you flip the roles, if you flip the names here, Amber promised him that if he ever left her, she would make his life a living hell by making him think of her every single day and by ruining her career and her life. That's a statement that is, I think, more accurate. I don't know. I think chat will agree. What do you think, chat? Do you think that that's a more accurate statement if you flip the roles? If you replace Mr. Depp with Ms. Heard, and instead of her you put him, I think that reads a lot more accurately. Let me know in the comments in the chat. After she obtained a protective order against him and commenced divorce proceedings, Mr. Depp did everything in his power to keep that promise. In describing Ms. Heard around the time of their divorce, by the way, that's not true because he kept silent. For 6 years, he kept silent. He spoke for the first time at the trial. So again, blatant misrepresentation. Hi, Zinni. Is it kitty time? All right, kitty break. This early on, she's like, I know we're going to have a kitty break, so might as well get it knocked out of the way earlier rather than later. He's like, you lost, Amber. Say bye-bye to your money and your career. Bye-bye. Bye-bye, career. It was nice knowing you. See, don't make up lies about people. Is she still in Spain? Does anybody know? Bye-bye. Bye-bye, career. She's so pretty. Isn't she like the prettiest girl? Mwah. Now she's like, all right, you've shown me to the world, now you can put me down. Bye-bye, Dad. I'll see you later. Okay. All right. Back to the show. Mr. Depp did everything in his power to keep that promise. In describing Ms. Heard around the time of their divorce, Mr. Depp stated, she's begging for total global humiliation. She's going to get it, and I will stop at nothing. And they're citing to the record. Mr. Depp has marshaled agents to advance his global campaign, including his lawyer, Adam Waldman. Mr. Depp retained Mr. Waldman shortly after announcing to the world he would stop at nothing to globally humiliate Ms. Heard. Mr. Waldman assists Mr. Depp with publicity, holds himself out to the press as Mr. Depp's lawyer, and has been quoted in several articles as stating Ms. Heard is carrying out an abuse hoax, which was the basis of Amber's countersuit, if you all remember. Mr. Waldman also works to generate negative press about Ms. Heard. Specifically, Mr. Waldman filed a report with the LAPD alleging Ms. Heard perjured herself and then created a story about his claim by telling a news outlet that the LAPD had opened a criminal investigation into perjury by Ms. Heard. The defamatory statement at issue in this appeal concerns the last occasion on which Mr. Depp physically abused Ms. Heard, May 21st, 2016. When describing this day to the Daily Mail, a tabloid published in the UK and online, Mr. Waldman falsely stated, quite simply, this was an ambush, a hoax. Ms. Heard and her friends set Mr. Depp up by calling the cops, but the first attempt didn't do the trick. The officers came to the penthouses, thoroughly searched and interviewed, and left after seeing no damage to face or property, which is now we know to be the truth. So Amber and her friends spilled a little wine, roughed the place up, got their story straight under the direction of a lawyer and publicist, and then placed a second call to 911. That will be henceforth known as the statement. So remember, when you see the words the statement, and statement is going to be capitalized, they're referring to this paragraph right here. This big paragraph right here. Following Mr. Depp's suit arising out of Ms. Heard's op-ed in which she described public backlash faced by women who allege violence, Ms. Heard filed a counterclaim for defamation seeking redress for the reputational harm caused by the statement that we just discussed. Mr. Depp moved for summary judgment, arguing the statement was an opinion and Ms. Heard could not prove actual malice. The Circuit Court of Fairfax County, the Circuit Court, correctly denied the motion, finding that the statement was actionable because it was capable of being proven false. The Circuit Court also denied summary judgment because the record contained disputed facts regarding whether the statement was made with actual malice. The case proceeded to trial, where the Circuit Court properly excluded the contents of the full article and contained the statement because it constituted inadmissible hearsay and was not necessary for the jury to assess whether the statement was defamatory. Okay, that's the legal issue. At the conclusion of the evidence on Ms. Heard's counterclaim, and again at the conclusion of all evidence, Mr. Depp moved to strike. Mr. Depp reiterated the arguments in his motion for summary judgment, contending the statement was an opinion published without actual malice. Mr. Depp also argued that he could not be held liable for Mr. Waldman's conduct because he was an independent contractor rather than an employee. The Circuit Court declined to revisit its ruling that the statement was actionable and correctly ruled that Ms. Heard presented sufficient evidence of actual malice. The court further held that Ms. Heard presented sufficient evidence that Mr. Waldman was acting as Mr. Depp's agent when he made the statement. Mr. Depp then tendered several jury instructions regarding his theory that Mr. Waldman was an independent contractor. The Circuit Court refused these instructions, holding the concept of an independent contractor did not apply to his case, and no evidence supported the proposed instructions. Following deliberations, the jury returned a verdict in favor of Ms. Heard with respect to the statement, just this one, not the other two. The Circuit Court entered judgment in accordance with the verdict and subsequently entered a final order. This appeal followed. Okay, just right out of the gate, I want to say something. Remember that at the end of the day, Johnny, I don't think really cares about winning or losing this appeal, honestly. I am of the firm belief that he would have never filed this appeal had Amber not filed hers. This is simply a knee-jerk reactionary moment for a couple of reasons. One, they have a chance. They actually have a shot, I do believe. I can't wait. I'm very anxious and itching to see what arguments they're about to make about agency, because agency is going to dictate like 90% of the judge's decision. Because if Waldman is determined to be an agent of Depp, then his statements could, in theory, be extrapolated to Johnny Depp, and therefore Johnny Depp could be liable for Waldman's statements. But if there's case law that says an agent speaking on behalf of their employer, essentially, cannot be vicariously liable, for example, well then, even if Waldman is an agent of Depp, the argument still falls apart. So it remains to be seen. Well, let's take a look at the facts. Let's take a look at the facts. Thank you for the dono, Sharon Sokolowski. Beautifully Damaged says, not a threat, his experience turned on her. Michelle Cavarnos says, very cute with respect to Zinnia. Thank you. Retired Nana says, would the Court of Appeals look at that comment and will wonder if this comment was true? Well, it depends. You have a duty of candor to the tribunal as an attorney. So the Court of Appeals is going to assume that the facts are true on their face unless they have reason to believe otherwise. Beautifully Damaged said that it was a reaction. Well, there you go. There's your proof. It was a reaction. Johnny doesn't care about appealing his $2 million judgment. He's only doing it because Amber filed her appeal. So, don't forget to like this video, comment below, subscribe to the channel. Check out the merch. There's a pinned product and there's some products below. Okay. The abuse on May 21st, 2016. Now we get to the statement of facts. This court views the evidence presented at trial in the light most favorable to the prevailing party, which in this appeal was Amber, with respect to the one statement. So viewed, the evidence at trial established that in May 2016, the party's marriage was falling apart due to Mr. Depp's alcoholism, drug use, and abuse of his wife. On May 21st, 2016, the couple had not seen each other for 1 month, but Mr. Depp contacted Ms. Heard and asked if he could come home because his mother had passed away. He told Ms. Heard that he really needed his wife, and while she felt conflicted because the situation hadn't gotten better with Johnny mentally due to his drinking and drug use, she agreed that he could return home. When Mr. Depp arrived in the early evening, he was inebriated. He was peaceful at first, but later began talking about a prank he insisted was carried out by one of Ms. Heard's friends, Tillit Wright. Mr. Depp claimed that Mr. Wright defecated in Ms. Heard's bed so that he would find feces there. Ms. Heard called Mr. Wright and placed him on speakerphone in an attempt to resolve the matter. During the call, Mr. Depp became angry, grabbed the phone, and screamed at Mr. Wright, who is a member of the LGBTQIA community. He yelled at the top of his lungs, "You dyke bitch," among other expletives and insults, and told Mr. Wright he could have Ms. Heard. Mr. Depp then tossed the phone on the couch and proceeded upstairs. Ms. Heard retrieved the phone and began apologizing to Mr. Wright. Mr. Wright, who was still on speakerphone and knew of Depp's abuse of Ms. Heard on previous occasions, responded, "Amber, get out of the house. Get out of the house now. You're not safe. Get out of the house." Mr. Depp heard this statement while he was on the staircase and bolted down the stairs. Mr. Depp grabbed the phone from Ms. Heard and began berating Mr. Wright again. After he finished screaming at Mr. Wright, Mr. Depp threw the phone at Ms. Heard, who was sitting on the couch. The phone hit Ms. Heard's face on what felt like her eye. I always found that statement absolutely bonkers, because when you get hit in the face, remember I mentioned this, I talked about this during the deposition review that we did. Here's the problem. When you're a female of a certain caliber, let's say, right? And in this case, we're talking about Ms. Heard, who is supposedly an actress, right? I can't call her an actress, I'm sorry. But she's a trying to be a wannabe actress, trying very hard. She admitted on the stand herself, "I am unteachable." Like, she literally said those words. "I am unteachable." Those were her words. Go look at her testimony from the trial. And now this woman, whose looks are everything, her entire career, if her looks dissipate, her career is over. Notice how she got the cheek implants to look more authoritative. Looks to her are the absolute most important, most critical, most crucial thing that she has in her possession as in trying to be actress, okay? To be hit on anywhere near where the most important features are located, because this is what the world sees. To get hit anywhere near that area would immediately cause such severe emotional reaction and anxiety to especially a person of that caliber. To get hit in what felt like her eye, how could you not? The first thing she would do is run to the bathroom, take a photo, send it to all her friends, say, "Look what happened, look what he did to me. I cannot act anymore. Oh, poor me. Yada da da da. Now what do? I need to go get this checked out, make sure that I'm okay." The first thing you do is run to a mirror. That's the first thing she would do. So the fact that this was I think I kind of felt like I maybe got hit by maybe somewhere near the eye is already a huge, huge red flag. Absolutely bonkers. The story has changed, says Pixie Doll. The documents from the trial. I call BS Nev from Catfish Exposed IO. There you go. This is nuts. This is absolutely nuts. This is not normal. Her reaction to the scenario is not normal. So it felt what felt like her eye. Ms. Heard put her head in her hands and just began crying. "You hit me with the phone." And this does not sound like something that Heard is known to be doing. She does not like to be the victim, right? She's the survivor. She's a fighter. And all of a sudden she very blatantly plays "I'm a victim" card. Doesn't make any sense. It just does not make sense. Does not comport with the reality of who Amber pretends to be, right? In response, Mr. Depp is now the big bully. "Oh yeah, I hit you, huh?" And then hit Ms. Heard on the top of her head and pulled her off the couch by her hair. Ms. Heard tried to cover her face to protect herself while Mr. Depp continued to pull her around the room by the hair and mocked her. Again, it doesn't make any sense at all. The whole scenario seems like it was written out of a script in a movie. Referring to her face, he said, "Let me see how bad I hurt you. Let me see how bad I hurt you this time. What if I pull your hair back?" At trial, Ms. Heard introduced numerous photos taken later that night and then the following days showing the marks and bruising on her face caused by Mr. Depp throwing the phone at her. And I think that's since been debunked. Meanwhile, at some point during the altercation, Mr. Wright called 911. The physical altercation subsided when Ms. Heard's friend, Raquel Pennington, who lived in an adjacent apartment, entered the room. Ms. Pennington got in between Ms. Heard and Mr. Depp, put her hands on Mr. Depp's chest, and said, "Johnny, no." Mr. Depp swatted Ms. Pennington's hands off his chest and barreled towards Ms. Heard, who had retreated to the couch. Ms. Pennington then covered Ms. Heard with her arms while Mr. Depp stood over them and screamed, "Amber, get the fuck up," about 10 times. At that point, 2 of Mr. Depp's security guards entered the apartment and persuaded Mr. Depp to leave. As Mr. Depp was leaving, he picked up a Magnum wine bottle that he had brought with him and smashed various items of personal property with the bottle. The damaged property included, by the way, and this is the incident where allegedly she was walking barefoot on like broken glass and she had absolutely no damage to her feet. There were no stains on her feet. There were no stains on her clothes. It just completely doesn't make any sense. Pixie Doll says, "You know 100% if you got hit in the eye." Exactly. Beautifully Damaged says, "She's too vain." I completely agree. Okay. The damaged property included framed photographs, displays of bead necklaces that Miss Pennington had prepared for an art show, and items in Miss Heard's office, such as keepsake boxes. Mr. Depp also spilled wine in the hallway outside their home. Ms. Heard presented evidence of this property damage at the trial. After Mr. Depp left with his security guards, Ms. Heard learned that Mr. Wright called 911 and law enforcement was on its way. Ms. Heard panicked because she did not know what law enforcement was going to do when it saw the property damage to her home. So she's more concerned about property damage than damage to her face? Oh, please. Oh, please. She was so worried about what this is going to do to Johnny that she went public with all this shit afterwards. Please. Again, she goes from yin to yang. It doesn't make any sense. People don't flip like that out of the blue. People are usually consistent, unless they're lying. When they're lying, they're inconsistent. But that's just me. She testified, quote, "I wanted to protect Johnny. I didn't want him to be arrested. I didn't want him to be in trouble. I didn't want the world to know. I didn't want the abuse to come out." Okay. Which is exactly why a year and a half later, 2 years later, you make it public in order to get more hits on your Aquaman movie. Please. Oh, please. It just reeks. This whole narrative just fucking reeks. Oh, sorry, I'm getting like a little in my nose, like, okay. She called her attorney, who assists her with entertainment law matter, for advice. So this is while the police are on their way. She had time to call a lawyer and like describe everything and what should I do? Like, really? No, the call was placed to the attorney and then the call was placed to the police. You don't just get on the phone and you're able to chick-chack, 7-8 minutes phone call with your attorney, figure everything out. She called her attorney, who assists her with entertainment law matters, for advice, and he gave her the contact information of a domestic relations attorney. As a result of a conversation with a domestic relations, so she talked to 2 lawyers. Okay. And then as a result of the conversation with a domestic relations attorney, before the cops arrived, by the way, they're already on their way. So it took them 2.5 hours to arrive on a domestic call? Please. Ms. Heard told the 2 law enforcement officers who responded that she refused to cooperate at the time based on the advice of her attorney. The couple's home was comprised of multiple apartments located in the Eastern Columbia building in LA. The apartments were often referred to as the penthouses at the trial. And I was there, and it's exactly what you think it is. Imagine like a small little like hotel like floor. Okay, imagine like a tiny hotel. And you have like, it literally says penthouse 1. I was going to take a photo, but it looked bland. It kind of looked boring. So I figured I'm just I think the doors were blue. I remember that. The doors were kind of like blue-green in color. And it literally says penthouse 1, penthouse 2, penthouse 3, penthouse 4, and penthouse 5. And they're right next to each other. And they all go out and they connect on the outside. Now, Johnny was renting all 5 of them. Okay? It's not common for somebody to just take and rent all 5 of them. It's just because Johnny could afford it, and he wanted it for Amber and her leeches. I mean, friends. I mean, squatters. I mean, friends. I mean, bloodsuckers. I mean, friends. Retired Nana says Rocky called the police first. Bessie Knox says, I can't wait for her to go down again. Not that she ever recovered to begin with, but though for 6 years she got away with it, so she'd never get caught. There you go. Welcome Ruth Mobley as a member for 6 months. Thank you, Ruth. We are so close to another emoji, by the way. Don't forget to like this video, comment below, subscribe to the channel, check out the merch. Johnny owned them. Yes, Pixie Doll. Exactly. Okay. After speaking with Ms. Heard, the officers walked through the apartments that comprise the couple's home with the 5 penthouses. And you literally, you can walk from one to the other very quickly. Gave Ms. Heard a business card in case she changed her mind about cooperating, and departed. No statements. And by the way, they testified. I remember there was testimony at the trial. I believe it was Officer Leonard, if I'm not mistaken, that there was nothing, no bruising on anyone's face, especially Amber's. I believe that was at the trial. Once the officers left, Ms. Heard and her friends cleaned up the apartments so their dogs did not step on any broken glass. And meanwhile, all these people are barefoot and walking around and stepping in broken glass with no cuts whatsoever. They did not call a publicist or summon law enforcement. But I thought law enforcement was already summoned. Okay. About an hour after the first pair of officers departed, however, a second pair of officers responded to the couple's home. Just randomly? Why would a random pair of officers respond if there was nobody calling them? Hello? Anyone? Anyone? That's not how it works. It's not like, oh, somebody already showed up. I'm sorry. I guess we're late to the party. We'll be on our way. Thank you for calling. Like, what? No. Ms. Heard did not know additional officers had been called until they arrived. Just more reeking bullshit. She declined to cooperate with the second pair of officers as well, and they departed after confirming Ms. Heard was safe and without searching the apartments. Which I believe is flipped, if I'm not mistaken. The first pair of officers didn't search. The second pair did search because now there was something to be found because they roughed the place up. Welcome, Claire. Welcome to the mini grills. Okay. Ms. Heard filed a petition for dissolution of the party's marriage at the end of May 2016. She realized after the violence on May 21st, 2016, that despite all of her efforts to help Mr. Depp become clean and sober with her own drug use, I presume, nothing was going to work. Mr. Depp's violent behavior was now normal and not the exception, and she feared that it was going to end really badly for her if she did not leave him. Ms. Heard also obtained a protective order against Mr. Depp at the end of May 2016 so that she could change the locks to their home. She explained that she had begged Mr. Depp's security guards, who carried his keys, to not let him into their home when he was intoxicated. But they always let Mr. Depp in anyway. As a result, she could not sleep and would often wake up with panic attacks. Okay. Ms. Heard's counsel notified Mr. Depp's counsel of her intent to seek a protective order, but Mr. Depp did not appear in court on the day she obtained the order. Ever since Ms. Heard obtained a protective order and filed for divorce, Mr. Depp has done everything in his power to destroy her reputation, her career, and her life. Wow. 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 What powerful words. And again, everything I'm reading, I swear, if you just flip the names as to who is the one that they are really speaking about. It's a true statement. It's a 100% true statement. But the name is wrong. It's the who's doing what to whom. They keep flipping the script. They're saying it is Johnny who is doing this to her. Johnny doesn't give a shit. We've seen this already. We literally see it on a day-to-day. It is her who is constantly wanting the attention, the attraction. She's addicted to this mindset of, did you know that Amber Heard is the #1 most searched for celebrity of 2022? Because nobody knows who the fuck she is. Johnny is #2, granted, but that's because of the trial. Everybody wanted to know what's going on with this trial, but she got what she wanted. She has earned her fame in the most vile, disgusting way possible by defaming openly someone of such a heinous act that is completely unprecedented. It's completely unprecedented. It destroyed and tarnished an entire movement. The Me Too movement is destroyed because of her. It's wild. You can't make this stuff up. It's the dramatic reading for me, says Pixie Doll. Aulaphobia says, how do you get past the other statements being found not defamatory and all of Heard's statements being found defamatory with this? It's a great question. Ben Rottenborn is a lawyer from Wish, says Pixie Doll. Beautifully Damaged says, baby, I love the way. Are we citing song lyrics now? I love it. Okay. Number 2, the statement of facts. Mr. Depp's intent to retaliate against Ms. Heard. Mr. Depp has deep anger and resentment towards Ms. Heard, which is, again, flip the names. Every time I read Depp Heard, just flip Depp Heard Heard Depp. I swear it reads like the truth at that when you do that. Mr. Depp has deep anger and resentment towards Ms. Heard, which is relevant to this appeal, because it demonstrates he was highly motivated to hire Mr. Waldman to defame her. You mean to get the truth out. During the relationship, when Mr. Depp became angry with Ms. Heard, he expressed his desire to kill her. For example, in June 2013, he sent a text message to one of his friends saying, "Let's burn Amber." In response, his friend proposed a drowning test, to which Mr. Depp responded, "Let's drown her before we burn her. I will fuck her burnt corpse afterwards to make sure she is dead." And I don't think we still have proof that Mr. Depp actually sent those. After Ms. Heard obtained a protective order, because we can't have access to her phone, because her phone was destroyed, remember? After Ms. Heard obtained a protective order and filed for divorce, Mr. Depp announced his plans to retaliate against her. For instance, in June 2016, Mr. Depp sent a text message to his sister, who works in the entertainment industry, stating, "I want her replaced on that Warner Brothers film." He was referring to Ms. Heard's role in Aquaman. In August 2016, Mr. Depp described Ms. Heard in a text message to her former assistant that stated, "I'm disgusted that I ever fucking touched that scum. Back on Tuesday, and then court. Will hit you when I get back, doll. Come over for a spot of purple, and we'll fix her flabby ass nice and good." Ellipsis in the original. Shortly before he met Mr. Waldman, Mr. Depp expressed his hopes that Ms. Heard would die and stated he would stop at nothing to globally humiliate her in a text message to his entertainment agent, which stated, "She's begging for total global humiliation. She's gonna get it. I'm gonna need your texts about San Francisco, brother. I'm even sorry to ask, but she sucked Mollusk's crooked dick and he gave her some shitty lawyers. I have no mercy, no fear, and not an ounce of emotion, or what I once thought was love for this gold-digging, low-level, dime-a-dozen, mushy, pointless, dangling, overused, flappy fish market. I'm so fucking happy she wants to go to fight this out. She will hit the wall hard," which we now know she did. "And I cannot wait to have this waste of cum guzzler out of my life. I met a fucking sublime little Russian here, which made me realize the time I blew on that 50-cent stripper. I wouldn't touch her with a goddamn glove. I can only hope that karma kicks in and takes the gift of breath from her. Sorry, man." By the way, karma has already arrived. "Sorry, man, but now I will stop at nothing. Let's see if Mollusk has a pair." They're referring to Elon Musk, for those of you unfamiliar, because she cheated on Johnny with Elon Musk. Let's see if Mollusk has a pair. Come see me face to face. I'll show him feelings he's never seen before, like the other side of his dick when I slice it off. Beautifully damaged. She's nothing, and to nothing she returns. Basically. Just Laura, welcome to the mini grills. Just another rando says he was out of the country and she had men sleeping in her bed. Tell me again how she was scared. Exactly. In light of this evidence, a fact finder could have concluded that Mr. Depp harbors deep animosity towards Ms. Heard and is desperate to destroy her reputation. Number 3, about the facts. Mr. Depp and Mr. Waldman's relationship. Mr. Depp retained Mr. Waldman in October 2016 and he continues to represent him. He serves as Mr. Depp's primary counsel for all of his affairs and has assisted Mr. Depp with filing several lawsuits, including actions against Mr. Depp's former business manager, his former attorney, a newspaper, and Ms. Heard. Mr. Waldman, who also assists Mr. Depp with publicity. In February of 2020, Mr. Depp and Mr. Waldman met with a publicist who works for the Daily Mail. At the meeting, or on another occasion, Mr. Waldman gave the Daily Mail 2 audio recordings concerning this case. Mr. Waldman has also provided information about this case to several social media personalities who he called internet journalists. He was present when a journalist for the Rolling Stone interviewed Mr. Depp, and according to the journalist, Mr. Waldman reached out to Rolling Stone about writing an article about Mr. Depp. There's a typo here. Reached out to Rolling Stone about writing article about Mr. Depp. Writing an article. Come on, Ben, get it together. After Mr. Depp and Mr. Waldman's meeting, the Daily Mail published a series of articles and accurately quoted Mr. Waldman. In an article published on April 8th, 2020, the Daily Mail wrote, Adam Waldman, Depp's lawyer, said, Amber and her friends in the media use fake sexual violence allegations as both a sword and a shield, depending on their needs. They have selected some of her sexual violence hoax facts as the sword, inflicting them on the public and Mr. Depp, which is now we know that's exactly what she was doing. On April 27th of 2020, the Daily Mail published a statement which accurately quoted Mr. Waldman as stating, quite simply, this was an ambush, a hoax. This is, again, the same statement. I don't know why they're repeating it here again. Again, you've already written it. Like, the judges get it. You don't need to keep repeating it. Just write the statement. They get it. But for effect, for emotional effect, which has no place in the appeal, there you go again. Dislike heavily. Judges don't care. Appeals judges don't care. District court judges care. Appeals judges don't care. Quite simply, this was an ambush, a hoax. They set Mr. Depp up by calling the cops, but the first attempt didn't do the trick. The officers came to the penthouses, thoroughly searched and interviewed, and left after seeing no damage to face or property. So Amber and her friends spilled a little wine, roughed the place up, got their stories straight under the direction of a lawyer and a publicist, and then placed a second call to 911, which is when the second pair of officers has arrived on scene. And on June 24, 2020, the Daily Mail published an article that accurately quoted Mr. Waldman's assertion that Ms. Heard was carrying out an abuse hoax against Johnny Depp. Each of these articles identified Mr. Waldman as Mr. Depp's lawyer or attorney. This is a completely stupid, just lawyer or attorney. Don't use lawyer or attorney. It's the same thing, basically. Like, in a brief, I swear, it's these little things, as a legal mind, they trigger me. I'm just like, why? Just why? Why would you do this? It accomplishes absolutely nothing, and it makes you look like an idiot. As a writer, like, pick one. You're not sounding more fancy, like a lawyer or attorney. No, like, no. Rottenborn is hurt hard over bad lawyers, says Pixie Doll. Anyway, I agree. Mr. Waldman has generated the content for negative press about Ms. Heard as well. He filed a report with the Los Angeles Police Department claiming that Ms. Heard and Ms. Pennington perjured themselves. Then, based on this report, we've gone over this already. Why are you saying it again? Or was that in the intro? I thought it was like the first argument, but maybe this was in the intro. Okay, I'll hold back. I'll hold back for now. We'll see. Then, based on this report, he told the German media outlet that the LAPD have now opened up a criminal investigation into perjury of Ms. Heard, which repeated this statement solely created by him in one of his publications. Mr. Depp and Mr. Waldman have enjoyed widespread success in generating negative publicity about Ms. Heard. An expert witness who analyzed negative tweets on Twitter about Ms. Heard found that between April 2020 and January 2021, over 25% of negative tweets about Ms. Heard were associated with a hashtag that included Waldman or a variation of his name. So sue him. The expert witness also detected a huge spike of negative hashtags towards Ms. Heard in February 2020, which coincides with when Mr. Waldman and Mr. Depp met with a publicist for the Daily Mail. Well, I mean, duh. You're stating obvious facts. When an article comes out, you're going to have spikes. But okay. Number 4, in the statement of facts. Mr. Depp's motion for summary judgment and motions to strike the evidence. Prior to trial, Mr. Depp moved for summary judgment, arguing, as relevant here, that Ms. Heard could not prove Mr. Waldman published the statement with actual malice, and that the statement was a non-actionable expression of opinion. Ms. Heard responded that both Mr. Depp and Mr. Waldman knew that the statement was false and that malice was therefore established. Further, because the statement accused Ms. Heard of fabricating evidence of domestic violence and then calling law enforcement, the statement was capable of being proven false and thus actionable. Agreeing with Ms. Heard, the Circuit Court observed that absent exceptional circumstances, the question of actual malice should not be decided at the summary judgment stage. The court held that a reasonable fact finder could conclude Mr. Waldman published the statement with malice because he has no personal knowledge of the underlying events at issue and nonetheless made the statement. The court also held that the statement was not an opinion because the assertion, I literally lost my place. The court also held that the statement was not an opinion because the assertion that Ms. Heard fabricated evidence of domestic violence can be proven false. At trial, Mr. Depp moved to strike at the conclusion of Ms. Heard's evidence on her counterclaim. He reiterated the arguments in his motion for summary judgment, contending the statement was an opinion, and clear and convincing evidence did not establish it was published with actual malice. He also argued that because Mr. Waldman is an independent contractor, not an employee, he is not liable for Mr. Waldman's defamatory statements to the press. Again, this is the whole argument. I don't know why we didn't just start here. This should have been page 1, not page 14. They always like to preface it with a bunch of fluff before they actually get to the real. It's so disappointing. And by the way, it works against them. Because when you have all this fluff, the judges are literally like, well, get to the point, and eventually they give up. You have no point. Okay, appeal overruled, denied. No, we're not going to give you what you want. Welcome to the Holy Grails, Patricia Burton. And thank you, Pixie Doll says, Elaine defamed Johnny Depp in the same way on TV. Right, exactly. He also argued that because Mr. Waldman is an independent contractor, not an employee, he's not liable for Mr. Waldman's defamatory statements to the press. Mr. Depp emphasized Mr. Waldman's testimony that he is not an employee of Mr. Depp. He is not issued a W-2 by Mr. Depp or one of his companies and provides legal services to clients other than Mr. Depp. In light of this testimony, Mr. Depp claimed that Mr. Waldman was an independent contractor as a matter of law, and as a result, he cannot be held responsible for any alleged tort by his attorney. In response, Ms. Heard observed that Mr. Waldman freely admitted to speaking to the press on Mr. Depp's behalf and clarified that Mr. Depp's liability stemmed from Mr. Waldman's role as an agent. The Circuit Court denied the motion to strike, finding that the only evidence in this case to the point that Mr. Waldman was an agent to Mr. Depp. The evidence showed that Mr. Waldman has served as Mr. Depp's attorney since 2016, and the scope of his legal representation was not limited to litigation. The court noted that cases holding attorneys or independent contractors are distinguishable because they involve attorneys who serve only as litigators for their clients. The court further held that a motion to strike is not a proper vehicle for challenging whether a statement is actionable, and declined to revisit its previous ruling that the statement was not an opinion. With respect to actual malice, the court observed that Mr. Waldman made the statement after meeting with his client. Both Mr. Waldman and Mr. Depp met with the Daily Mail, and Mr. Waldman threw a paper containing the counterclaim statements at Ms. Heard. Based on this evidence, the jury could infer that Mr. Waldman made the statement with actual malice. At the conclusion of the evidence, Mr. Depp renewed his motion to strike, and the circuit court denied for the same reasons as the initial motion. Okay. Number 5, about this. I can't believe we're still on the statement of facts. This is literally page 15. Again, it's so unprecedented. It is so unprecedented to have such long, drawn-out facts in an appeal. Normally, you just want to get it cut and dry. You know what I'm saying? Just cut and dry. I don't understand. Black dots on red, welcome to the mini grills. We are so close to that emoji, you guys. I think we only need like a few more, and we can get another emoji going on the channel. I think you all wanted Amy Goodhart. We can get Amy Goodhart as an emoji. Don't forget to like this video, comment below, subscribe to the channel. Number 5, the refused jury instructions on independent contractors, and join on as a member. Mr. Depp tendered proposed jury instructions 22, 23, 24 regarding independent contractors for the circuit court's consideration at a hearing before the conclusion of the evidence on May 20, 2022. At the hearing, the circuit court rejected Mr. Depp's argument that the concept of an independent contractor applies when ruling on separate proposed jury instructions. Now, when raising his sole objection, regarding independent contractors to those instructions, Mr. Depp stated they should address the agency issue because you only get to liability on behalf of Mr. Depp if the jury also finds that he's not an independent contractor. The circuit court refused to instruct the jury. This is one of the issues on appeal for Johnny, explaining an attorney and a client have a principal and agent relationship and there's no evidence of an independent contractor. When the circuit court considered proposed jury instructions 22, 23, 24, Mr. Depp did not present additional arguments in support of instructing the jury on independent contractors. The circuit court referenced its previous rulings and denied the instructions over objection. At the conclusion of the evidence, the circuit court held another hearing on jury instructions, where it ruled on instructions taken under advisement and additional instructions Mr. Depp tendered after the previous hearing. Mr. Depp did not ask the circuit court to revisit its rulings on proposed jury instructions 22, 23, 24, nor did he challenge the ruling that no evidence suggested Mr. Waldman was an independent contractor by arguing that evidence presented after the previous hearing supported these instructions. While Mr. Depp has not relied on evidence presented after the May 20th, 2022 hearing on brief, evidence presented after this date, such as Mr. Depp's testimony on May 25th, 2022, day 23 of the trial, should not be considered when determining whether sufficient evidence supported these instructions because the circuit court had no opportunity to consider this evidence. Now, this is important. This is important. If it wasn't raised as an issue, but the question is, was it raised as an issue sufficient for preservation on appeal or not? So just because it wasn't raised on that day doesn't necessarily completely destroy the argument. If it wasn't raised at all, which doesn't sound like it wasn't, it absolutely was, motions to strike and all that. So they're saying that because you didn't do it on this particular occasion, you waived your right to argue that issue. Fine. That's their argument. Rule 5A:18 requires a litigant to make a timely and specific objections so that the trial court has an opportunity to rule intelligently on the issues presented. Again, the court has already ruled, so I don't know. That one seems a little weak. That's why it's at the end. When instructing the jury, the circuit court gave instructions that fully and fairly cover the agency issues raised by the evidence. The jury instructions explained the burden of proof of agency, defined the terms principal and agent, and described the scope of an attorney's authority. All right. Now we get to the meat. The real juicy stuff. Can you believe that this was, up until this point, this was just basically the introduction? Basically just the statement of facts. Now we get to the real crux of this brief. The arguments as to why Johnny should lose his appeal and Amber should win. Welcome Danny G as a member to the channel. Welcome to the mini grills. This is gonna be interesting. So buckle up, Buttercup. Argument numero uno. Mr. Depp's independent contractor theory is inopposite, and whether Mr. Waldman is his agent is a question, or was a question, of fact. This is relating to assignments of error 1A and 2 of the appellant. As always, we start with the standard of the review. How is the court supposed to make this analysis? A plaintiff who is armed with a jury verdict approved by the trial court stands in the most favored position known to the law. Basically, you're favoring the plaintiff. But in this case, it's the defendant, Amber, who won this claim, and Johnny is appealing it. Make sense? I know it can get very confusing, especially since we have two parallel appeals going. But this is Johnny's appeal. This is Amber's response to Johnny's appeal, for those of you just joining us, okay? You gotta literally zero in on it. Welcome Salem's Mom and M's Maurice to the Mini Grills and Holy Grills, respectively. Okay, when a trial court has refused to strike a plaintiff's evidence, the well-established standard of appellate review requires this court to determine whether the evidence presented at trial, taken in the light most favorable to the plaintiff, was sufficient to support the jury verdict in favor of the plaintiff. Citing the same Dixon case. Whether the concept of an independent contractor applies to the case is a question of law reviewed de novo. So remember, we have basically two standards of review that have been used most commonly. It's abuse of discretion and de novo. Abuse of discretion is when you're looking at the judge and you're going, okay, you had an opportunity to rule this way or that way, you ruled this way, and you abused your discretion in doing so. This is not one of those occasions. This is a review de novo. You ignore everything that has happened. You don't care what the judge did other than like their actual decision. And you compare that to the law. Does it comport with the law? We look at it with fresh eyes. I like to say it like in Spanish, de nuevo. Nuevo means new in Spanish. We look at it anew, fresh, okay? And whether Mr. Waldman was acting as Mr. Depp's agent when he made the statement was a question to be resolved for the jury. And the jury's findings should not be disturbed on appeal unless it is plainly wrong. And they're citing a case, Tingler. Mr. Waldman can be both an independent contractor and an agent. So they're laying out the strongest fact, by the way, their strongest argument that this shouldn't even be touched because it's a question of fact. There are two questions, really, that a court can decide. Questions of fact and questions of law. Questions of fact are decided by the trier of fact. Sometimes it's a jury, sometimes it's a judge. In this case, it was a jury. Questions of law still exist in a jury trial that a judge has to determine which jury instructions to give, for example, to determine whether or not an individual is an agent or an independent contractor is another example, particularly in this appeal. So those are questions of law. What Rottenborn and his team are arguing is that this is an entirely reserved question of fact. You don't even get to ask it as a question of law. It's already been decided. The jury made a decision. Leave it alone. Should be undisturbed. Definitely their strongest argument. Mr. Waldman can be both an independent contractor and an agent. Mr. Depp claims that Mr. Waldman is, as a matter of law, an independent contractor rather than an employee agent, and is thus not liable for his statements to the press. Agency is defined as a fiduciary relationship arising from the manifestation of consent by one person to another that the other shall act on his behalf and subject to his control, and the agreement by the other to do so. When an agent commits a tort while acting within the scope of his authority, the principal is liable. And that is the definition of agency. When the agent acts under color of authority and is determined to be an agent, the principal is vicariously liable, this is the magic language, vicariously liable for the acts of his agent. This is the entire argument. This is the central crown jewel, the crown jewel piece of this whole appeal response. Amber is saying, her lawyers on her behalf, but it's in legal terms, Johnny says this, Amber says this. This is how you talk about it on appeal, because you're not like, well, I'm the lawyer and I'm writing. Everybody knows. We get it. You have an agent, Waldman. He makes a statement. If he's determined to be an agent, then the principal, Johnny, is liable for Waldman's statements. Even though Johnny did not make them, Waldman, if he made them under the color of his agency, the principal, Johnny, would be liable. As you can see, this is exactly what this definition is. Let me read it again because this is so important. When an agent commits a tort while acting within the scope of his authority, the principal is liable. It's kind of like when you are on the job and you get into a car accident and you are going to a location to perform a job, let's say. Workman's compensation should kick in. Why? Because you were, let's say, in a work vehicle going to a work location, you are on the job. You are an agent of your employer. And your employer now is required to pay for the damages that you may have sustained, or his insurance, obviously, or her insurance. It's the same concept. It's the same concept in simple terms. Welcome, Patricia Brown, to the mini grills. So that's the argument. That's the argument. In his assignments of error, filed on October 11th, 2022, Mr. Depp asserted that Mr. Waldman is an independent contractor, not an employee agent. In his opening brief, Mr. Depp revised his assignment of error and omitted the italicized language. It is impermissible for an appellant to change the wording of an assignment of error. While substantive... Oh, please. Well, they're being nitty-gritty. Fine. I don't know if it was an intentional thing or an accidental thing, but that's just fine. While substantive changes to an assignment of error can result in default, an appellate court has discretion to address the merits of an assignment of error while the alteration appears substantive, but issues pertaining to appellant's omitted assignments of error are encompassed by the presented assignments of error and are sufficiently briefed. In these cases, the court refers to the original assignment of error. Okay, look at the original language, not... They're literally sticking to the fact that this language was omitted in the assignment of error by Mr. Depp. I don't know how relevant that is and how much does it really matter, but they mentioned it. That's very interesting. They're saying that Johnny omitted that italicized language in his brief. Then was Waldman on the clock when he made the comments? Well, Ems Maurice, that's not the question. They're not saying whether or not it's a frolic or a detour, because if it's a detour or a frolic, that would be a whole other different conversation. They're saying that he was an agent, period. It doesn't matter if he was on the clock in that moment. Agent is an agent basically all the time in that sense. Okay? Fantastic question, Ems Maurice, by the way. Fantastic question. So explaining that principal is liable for the torts of his agent, even though the principal did not authorize or justify or participate in or indeed know of such misconduct, or even if he forbade the act. So basically, imagine Johnny saying, no, Waldman, do not write this. And Waldman writes it anyway, and now Johnny's on the hook. That's what they're arguing. If he's an agent, Johnny would be on the hook. Recognizing that defamation may be based on statements made by an agent. Was this thing rushed? Ben Rottenborn, get your shit together. This is a second mistake in the brief. I mean, it's simple words, but they get thrown in your face. And judges don't like that. Based on statements made by an agent. Strike two, man. Come on. What the fuck? An agency relationship can arise in any circumstances and is not limited to the employment context. See, for example, this case, affirming jury verdict against mother arising from against a mother. Is this strike 3? Let's see. Affirming jury verdict against mother arising from motor vehicle accident caused by her son, who was acting as an agent when the accident occurred. Against mother. It might work. I don't know. But still seems wrong. Just stylistically doesn't work. In the employment context, a person's status as an independent contractor precludes the existence of an agency relationship. This is the doctrine of respondeat superior. Vicarious liability, respondeat superior, they're synonyms. They're the exact same thing. This is just Latin lawyer bullshit speak for those of you unfamiliar. The doctrine of respondeat superior, or the doctrine of vicarious liability, literally the exact same thing, imposes liability on an employer for the negligent acts of its employees. If, however, the negligent acts were performed by an independent contractor rather than employee, no master-servant, this is legal terms, master-servant relationship exists between the contractor and the employer is not liable for the negligent acts. Unlike the employment context, when an individual's status and an independent contractor precludes the existence of an agency relationship, it is beyond dispute that an attorney and client have an agency relationship. And I hate this language. Again, don't just say it, say why. Argue it. It is beyond dispute that an attorney and client have an agency relationship doesn't mean shit to a judge. Cite case law. Give me the law. Don't give me your facts. Give me the law. The concept of an independent contractor is an opposite for this reason alone. The concept of an independent contractor, however, does not apply in all agency contexts, nor does establishing an individual as an independent contractor defeat the possibility of any agency relationship in the first place. For example, in this one case in Illinois, vicarious liability may nevertheless be imposed for the actions of independent contractors where an agency relationship is established. Now, that is a bomb. They're basically asking the Virginia court to say, look at Illinois. Illinois doesn't even care. Vicarious liability can still be imposed on the actions of independent contractors. You don't need a master-servant agent type relationship, so long as you at least have that. You're good. Then you're absolutely good. Texas, agency and independent contractor status are not mutually exclusive. Utah, same. Oklahoma, same. The 10th Circuit, same. We don't have a Virginia case here. Notice. We don't have a Virginia case. Why? Because Virginia doesn't follow this. This appears to be a minority rule. There are two types of rules in these types of cases, in appellate cases. You have majority rules and you have minority rules. Majority rules is the majority of states subscribe to. Minority rules are the minority of states subscribe to, and they apply to a host of different legal issues. In this case, when it comes to agency, you have at least several states in one circuit that don't even care. Don't even care. Are you a principal agent or are you a principal independent contractor? They're going to hold the principal liable no matter what. So if we were in Illinois, we probably may not even be having this appeal, or it would be an appeal on different reasons, in different legal arguments. But they're basically saying, Virginia, you should look at these states and change the law. This is what you do on appeal. This is how laws get created. And Mr. Depp is incorrectly, they continue on with the argument, is incorrectly importing the concept of an independent contractor, which negates an employer-employee relationship, a specific kind of agency relationship, to all agency contexts. And in doing so, he has presented a false dichotomy by arguing Mr. Waldman is either an independent contractor or an agent. A false dichotomy is a logical Okay, are you seriously going to argue what a false if you have to explain what a false dichotomy is to a judge, you're in the wrong place, bud. They can look it up themselves. That's kind of insulting. I'm not gonna lie. I wouldn't do that if I were you. A false dichotomy is a logical fallacy based on the false premise that only two mutually exclusive options are available, when in fact the option are not mutually exclusive, or there are more than two options. See, for example, false dilemma with a wiki article. You cited to Wikipedia? And by the way, that is not in your sources. You'll have to include that in your sources. That's not included in your sources. Probably because you were embarrassed by it, because you're citing fucking Wikipedia. Why are you citing? Just cite to Black's Law Dictionary. If it's not found in Black's Law Dictionary, find it in the Webster's. Don't cite to Wiki in your brief, man. Lisa asks a great question, but what if he said was true? Well, that's the question for the jury to decide, and the jury decided that it was not true. That's why they gave Amber the $2 million. Wow. But okay, all right. Not only are you citing to Wikipedia, you're literally like defining what a false dichotomy is for judges. I think they can do their job themselves, bro. Ugh. Gross. Just gross. Not a good way to write, honestly, in my opinion. But the two are not mutually exclusive because Mr. Waldman can be both an independent contractor and an agent. Even if Mr. Waldman is an independent contractor, it does not preclude Mr. Depp's liability for Mr. Waldman's defamatory statements to the press. As a result, subpart A of the first assignment of error and the second assignment of error do not assert any grounds for reversing the judgment of the circuit court. So that's their argument. That's part B of the first argument. It doesn't even matter. Independent contractor, agent, who cares? Liability is there. End of story. Move on. That's what they're arguing. Look at these other states, judges. Look at these 5 or 6 states that we mentioned, and you should adopt this same rule here in Virginia. Okay. Very condescending. Yeah, I agree. Very condescending. These are judges who may have been judges for years. And they're like, well, let me define what a false dichotomy is. A false dichotomy means such and such. And if you look at the Wikipedia article that I have cited, because I know you don't have a means of looking it up on your own, just press this link. Don't like. Dislike. The circuit court properly denied the motions to strike because whether Mr. Waldman made the statement while acting as Mr. Depp's agent was a question of fact. Again, this is in the jury's prerogative, nothing to do with you all. That's basically what that is saying. Don't forget to like this video, comment below, subscribe to the channel, and join on as a member if you're so inclined. We're so close to our new emoji. With your help. In his opening brief, Mr. Depp has relied exclusively on his independent contractor theory to challenge whether Mr. Waldman was acting as an agent when he made the statement. Thank you, Pixie Doll. She's convinced Ben Rottenborn was a bully in school. It's very possible. I don't know. I have no proof one way or the other. Depp has not asserted Ms. Heard presented insufficient evidence that Mr. Waldman was his agent or that he was acting within the scope of his authority. And those arguments are therefore waived. So, arguments that are not preserved on the trial level are waived. No question. And if they're not arguing, then they're not arguing it. They're arguing something else, which we already know what it is. If you haven't seen, go to the video. Johnny's brief is absolutely nuts. It's on my channel. Rule 5A 20E requiring the support of each assignment of error. Right. To the extent the court interprets Mr. Depp's contention that Mr. Waldman is an independent contractor as a matter of law, as challenging the sufficiency of the evidence on agency, the circuit court correctly denied the motion to strike. So, as the appellee, a lot of times you find yourself kind of siding with the judge's decisions. The appellant does the complete opposite. The appellant's like, look, the judge got it wrong, and here's why, and here's law to support why they got it wrong. Meanwhile, the appellee's like, no, they got it absolutely right, here's why they got it right, and you should agree with them. Notice that pattern. Whether an agency relationship exists is a question to be resolved by the fact finder unless the existence of the relationship is shown by undisputed facts or by unambiguous written documents. Whether a person is an employee or an independent contractor is generally a question of fact for the jury. Agency may be inferred from the conduct of the parties and from the surrounding facts and circumstances. And by the way, the fact that the trial court denied these instructions to be placed in front of the jury in the first place may be the sole basis for overturning the verdict, by the way, on behalf of Amber, the $2 million. Because if they're like, well, the jury should have been instructed on this stuff, we understand all of this, this is fantastic, but the jury made the wrong decision because they weren't fully aware of the facts of what they should have been deciding, then Amber is going to have a host of problems, and none of this is going to matter. Agency may be inferred from the conduct of the parties and from the surrounding facts and circumstances. Indeed, because direct evidence of agency is not indispensable and frequently is not available, circumstantial evidence may be relied upon, such as the relation of the parties to each other and their conduct. Frequently, agency is established and has, of necessity, to be established by circumstantial evidence. A principal's liability does not turn on whether it directed its agent to take a certain action. Rather, the test of the masters, this is the test. This is how you determine whether or not you have a master-principal relationship. Welcome, Elasor123 to the mini grills. Welcome, welcome. The test of the master's responsibility for the acts of his servants is not whether such an act was done in accordance with the instructions of the master to the servant, but whether it was done in the prosecution of the business. Such antiquated language. Master, servant, prosecution of the business. It's very, very old, if you can't tell yet. But it's been around for eternity. The prosecution of the business that the servant was employed to do, and as an act, an act is regarded as authorized in the legal sense if it is incidental to the performance of the duties entrusted to the servant. This is the most critical language. I'm going to read it again because, again, we're coming back to the whole central crux of Amber's argument of why Waldman is Johnny is Waldman when it comes to the statements made. An act is regarded as authorized in the legal sense if it is incidental to the performance of the duties entrusted to the servant. This is how Amber is trying to win this. Even though it may be in complete disobedience of the master's express orders and instructions. So again, remember the whole thing. It doesn't matter if Johnny would be like, no, don't do this. No, absolutely, Waldman, don't do it. Don't do it. Don't go. Don't do it. Don't say it. And Waldman's like, well, fuck you. I'm going to say it anyway. And then they're like, well, Waldman, you were an agent of Johnny. Johnny could be held liable. Welcome, Segan Rose, to the mini grills. That's the argument. Applying this test outside the employment context and concluding a mother was... so that was number 3. We did find 3 grammatical errors so far. A mother just dropped words. They're just dropping words. Is it for the word count? I don't know. Did they just fuck up? I don't know. And concluding a mother was liable for damages arising out of a motor vehicle accident. But see, a motor vehicle accident caused by her son, notwithstanding that he disobeyed her instructions by driving the vehicle because the son was performing the very act or class of service he was instructed to do to complete by returning the vehicle to his mother. A motor vehicle accident is a very different fact scenario. I see what they're trying to do, and they're trying to create a parallel. And a lot of times lawyers make this mistake. They look at 2 cases and they're like, oh, this case is like my case, and not realizing that it is a completely different context and it does not apply. We saw a lot of that in Amber's brief when she tried to be like, well, this is kind of like this. And we're like, no, it's not, as we analyzed it together. If you haven't seen it, it's on my channel. It's completely not like your case here. You're trying to make the parallel, and I understand what you're trying to do, but you're failing, and it's not working. This is not, it's not a very good parallel, in my opinion, because that is just a single act by an individual acting under direction and instruction. Son, return the car to me. There is no evidence. Actually, we have evidence of the contrary. That Johnny was like, I had no knowledge that Waldman made this statement to the press when he did so. Okay? He didn't say, go and do this, and Waldman was like, yes, sir. Well, I understand it doesn't matter with in the context of a master servant, as we saw the definition. That's no problem. We get that. But you're trying to compare yin and yang, and it's not working. It just doesn't serve your cause. Those are completely two very different scenarios, legal scenarios, factual scenarios. Acts within the scope of employment include those taken with the intent to further the employee's interest. Now that's more on point. Kensington is more on point, but not Thomas v. Wingold, the mother and son scenario. That's too out of left field. Accordingly, Mr. Depp's assertion that he's not liable because he was not personally involved in directing or making the statement is incorrect. He entrusted Mr. Waldman to be his mouthpiece in continuing to defame Ms. Heard through public statements as part of his campaign. So they're saying it is like the mother and son, right? Which I think so far the facts have proven to be otherwise. As part of his campaign of self-described global humiliation against her. There's that language again, that powerful language that they like to use. Aolophobia says the only evidence to infer was the no comments. Beautifully Damaged says, so Elaine is AH's agent for TV fiasco. There you go. Is Johnny going to pursue a claim against her? I don't know. Maybe, maybe not. Don't forget to like this video, comment below, subscribe to the channel. Thank you, Sharon Sokolowski, for the dono. Furthermore, whether Mr. Waldman was acting, global humiliation against her. In so doing, Mr. Depp made Mr. Waldman his agent for those purposes. Furthermore, whether Mr. Waldman was acting as an agent when he made the statement was an issue of fact, and the jury's finding is supported by ample evidence. The evidence established that Mr. Depp seeks to retaliate against Ms. Heard for obtaining a protective order against him and filing for divorce. Shortly after announcing that he will stop at nothing to globally humiliate her, Mr. Depp retained Mr. Waldman, who serves as his primary counsel for all his affairs and assists him with publicity. Mr. Waldman has spoken to the press on Mr. Depp's behalf on several occasions. For example, Mr. Waldman confirmed that he was accurately quoted by the Daily Mail in articles published on April 8, 2020, April 27, 2020, and June 24, 2020. Mr. Waldman was identified as Mr. Depp's lawyer or attorney. There it is again. I don't understand. Just use one, pick one, and move on. In each of these articles, Mr. Waldman has also provided information about this case to several social media personalities and was present when a journalist for the Rolling Stone interviewed Mr. Depp. So see, now they're tying the facts to the law. They're saying, we outlined the facts, we outlined the law, now you got to tie it together. Issue, rule, application, conclusion. For those of you law students out there, you know exactly what I'm talking about. This is literally IRAC in the works. IRAC, not Iraq, the country. IRAC is what lawyers and law students use to make sure that their argument is legally cogent and lawfully sound and makes sense, and that they cover all their bases. This is the application portion. Mr. Waldman has also provided information about this case. Before the articles in the Daily Mail were published, Mr. Depp and Mr. Waldman met with a publicist for the Daily Mail on or around February 7th of 2020. Mr. Waldman gave the Daily Mail 2 audio recordings concerning this case, but could not recall if he did so at the meeting or on another occasion. Mr. Waldman also generated negative press about Ms. Heard by filing a report with LAPD that claimed Ms. Heard perjured herself. After filing this report, Mr. Waldman generated press about his own accusation by telling a media outlet that LAPD have now opened up a criminal investigation into perjury of Ms. Heard, even though all that happened is that Mr. Waldman had made a police report. In summary, during the course of Mr. Waldman's representation, he and Mr. Depp met with the Daily Mail, which then published a series of negative statements by Mr. Waldman about Ms. Heard. The Daily Mail accurately quoted Mr. Waldman and stated he was Mr. Depp's attorney. Mr. Waldman also provided the Daily Mail with 2 audio recordings concerning this case. He communicated about this case to several other media outlets and has actively generated the content for negative press about Ms. Heard. While the concept of an independent contractor is irrelevant in this case, this evidence demonstrates, according to Ms. Heard, that Mr. Waldman is not an independent contractor as a matter of law because a fact finder could have concluded that Mr. Depp has the right to control Mr. Waldman's publicity work. Power to control an individual's work is determinative of whether he is or she is an employee or independent contractor. For instance, Mr. Depp's presence at the meeting with the publicist for the Daily Mail supports the inference that he has the right to control Mr. Waldman's statements in the Daily Mail. That's their argument. Based on this evidence, a trier of fact could have concluded that the scope of Mr. Waldman's representation involved generating negative publicity about Ms. Heard, or speaking to the press, including the Daily Mail, on Mr. Depp's behalf. Alternatively, a fact finder could have concluded that Mr. Waldman had authority to speak to the press about Mr. Depp's behalf, or to generate negative publicity about Ms. Heard without making any finding as to whether doing so was part of his role as an attorney. In either case, Ms. Heard presented sufficient evidence, that Mr. Waldman was acting as an agent when he made the statement because this action was incidental to the performance of the duties entrusted to him. The Circuit Court therefore correctly denied the motions to strike. Part 4 of argument number 1. The court need not adopt any rule regarding whether attorneys are independent contractors as a matter of law. So now, after going through why you should adopt it, we're going to go through the argument of if you don't want to adopt it, you don't even have to. Bessie Knox says she's obviously going to epically lose again. Thank you, Dina, for the donation. Don't forget to like this video, comment below, subscribe to the channel if you like this content. Or even if you don't, like it anyway. And subscribe anyway, because I have a lot of cool stuff coming. This court should reject Mr. Depp's request to adopt the rule that clients cannot be held liable for their attorney's misconduct because they are independent contractors as a matter of law for several reasons. First, several courts have held that attorneys are not independent contractors, so now we're going to other jurisdictions, again, because Virginia doesn't have it, and have imposed liability on defendants for their attorneys' torts. For example, South Carolina held that defendant can be held liable for its agents' attorneys' actions taken within the scope of representation, including possible torts committed by him or her, and that the trial court did not err by instructing the jury only on agency principles and not independent contractor law. Arkansas, similarly, held that a client may be held vicariously liable for the actions of his or her attorney, so long as the attorney is acting within the scope of employment and in accordance with what is believed to be in the client's interest. Texas, finding the client vicariously liable for his attorney's intentional torts because the actions arose directly out of the business that the attorneys were hired to do and were committed for the purpose of accomplishing the mission entrusted by the attorneys. Maine, I think that's Maine, M-E, I think that's Maine, holding that defendant could be held liable for his attorney's tort when the tort arose out of an agency relationship which existed between the defendant and his attorney, even though the defendant did not specifically authorize the tortious conduct. Indiana, Northern District of Indiana, accepting as true allegations that an attorney made defamatory statements to the press on behalf of defendant and noting that it would be ultimately a question of fact for the jury to decide. North Carolina, holding that a client is liable when an attorney is guilty of oppressive or wrongful conduct during the course of the proceeding in order to enforce a claim of the principal. So these are all states that Amber is arguing, like, look at South Carolina, look at North Carolina, look at Texas, look at Maine, look at Indiana. They're all saying that defamatory statements made, it's a question of fact for the jury to decide. Call it a day. Are they a principal? Are they an agent? It's not even a question of law. The jury decides. Now, Virginia doesn't have that. Virginia doesn't have it, so they're saying you should adopt these rules. You should adopt these rules, Virginia. These are good rules. You should follow those rules from the other states. 4C process says, only AH said JD used slurs against IO. I'm a member of the LGBTQIA plus community too, and that would stick in me like a knife. But IO never mentioned that. Thank you, 4C process. Yes, Hayby, this does have a page limit. 50 pages. They did not request for an extension on this one. Okay, second, none of these cases Mr. Depp cites involve whether a client can be held liable for his attorney's defamatory statements to the press, and most are distinguishable for additional reasons. See this case from Virginia now, applying the Fourth Circuit's test for determining employee status specifically in the context of Title VII in the Age Discrimination in Employment Act, rather than examining vicarious liability for intentional torts. California recognized that an attorney may act as an employee for his employer in carrying out non-legal functions or business transactions. Georgia, noting that an attorney was retained for the sole purpose of collecting monies upon a judgment when reaching its holding that the attorney was an independent contractor, unlike Mr. Waldman, who was retained for several purposes that include litigation and publicity. Illinois, again, that someone is an independent contractor does not bar the attachment of vicarious liability for her actions if she is also an agent. New York, holding an insurance company was not liable for the acts of its attorneys, where imposing liability would make the company liable for actions it could not legally control due to specific New York law. This is the first time they decided to randomly throw in where it doesn't apply. I'm not exactly sure why. It's good. It's good to show both sides of the coin, but they just cite one, and it sounds like there might be more. But they just decided to throw one in there for good measure. It's like, look, we're not totally hiding the ball. Here's one. New York is not like it. Back to Texas. Noting party to a civil suit. Notice how it's kind of squished in the middle to be kind of ignored. It's very strategic. Brief writing is an art. There are literally people who, like Andrea Burkhart, who specialize in appeals work, and that's all they do is appeals, and they do nothing else for the most part, or maybe do very little of other stuff. So, noting that a party to a civil suit in Texas cannot be liable for the intentional wrongful conduct of his attorneys unless the client is implicated in some way other than merely having entrusted his legal representation to the attorney, which is unlike the facts of his case because Mr. Waldman assists Mr. Depp with publicity as well as legal representation. And notice how they keep falling back on that argument, is that Depp hired Waldman not just to be his lawyer, he also hired him to be his publicist. That's how he morphed from an independent contractor to an agent, because he's doing all that much more. Third, several of the cases cited by Mr. Depp emphasize that imposing vicarious liability on an client, strike 4, man. Rottenborn, highly disappointed with you, man. Strike 4 on grammatical errors in a brief. Oy, 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 man. This just shows this wasn't proofread. This was rushed. You had 30 days, man. You had 30 days to do this. And you fuck it up over and over and over. We just barely got halfway through and I already caught 4 grammatical mistakes. 4. Emphasize that imposing vicarious liability on a client for actions taken during the course of legal representation would lead to negative consequences for the legal system, including making parties reluctant to file suit or giving ill-equipped parties the ultimate responsibility over their legal representation and encouraging clients to micromanage their attorneys. Again, Texas and Illinois. Those 2 states, by the way, Texas and Illinois, seem to be really against attorneys making these types of statements on behalf of clients. So if you're going to do that, make sure you're not committing defamation, because your client will be on the hook. Texas and Illinois in particular. They're cited over and over and over again. These concerns are minimal here, where Mr. Waldman spoke as Mr. Depp's agent to the press, outside of the bounds of a traditional legal relationship, and Mr. Waldman's assistance with publicity only tangentially involved litigation. Last, clients generally rely on their attorney's professional skill and judgment with respect to intricacies of the legal field. In such cases, clients have little ability to monitor whether an attorney's conduct is tortious because they lack legal knowledge. And when an attorney speaks on their client's behalf to the press, no legal skills or judgment are involved. And consequently, which is not true, by the way, you have to be very careful what you state and how. I mean, case in point, he got sued for defamation over it. So yes, legal skills and judgment are involved. Absolutely. That's a false misstatement of fact. And consequently, holding a client liable for his attorney's defamatory statements is warranted. Okay, that's the argument. Accordingly, this court can assume, without deciding, that attorneys are independent contractors, hold plaintiff may nonetheless prove a client is liable for the acts of his attorney, where those acts are not part of the attorney's legal representation in litigation or do not otherwise involve an attorney's professional skills or judgment. The doctrine of judicial restraint dictates that we decide cases on the best and narrowest grounds available. Whew, that was a mouthful, and that was argument number 1. We still have a few more to go. Trying to bail out Elaine while trashing JD, says Pixie Doll. I don't think that's happening. So let me just give you my brief thoughts so far on the first argument. I know you all are dying to hear it because you all heard a bunch of legalese and you're like, well, what does this mean? It simply means this is what Rottenborn is arguing on behalf of Amber. He's saying, look, basically the judge got it right. The jury got it right. There's absolutely no question that Waldman is an agent. And even if he's not, if he's an independent contractor, you can still hold him liable regardless. And because he's liable, he's as an agent, he's on the hook. JD is on the hook because he's the master in this master-servant relationship. Okay? How Johnny is going to combat this, again, we haven't gotten to this yet. This may be argued in the future because this is just the first argument. But Johnny has to focus on the fact that the jury got it right with the limited instruction that they had. If the judges on the Court of Appeals determine, I already said this, I'm going to say it again because this is so important. So important. This is probably the crux of Johnny's case. If, and this is a huge and very important if the Court of Appeals decides that, you know what, maybe he was an agent. Maybe he was. But for us, it's irrelevant because the jury was insufficiently informed in their instructions to them by the court. For example, they should have known instructions 22, 23, 24, the definitions, what it all means, principal, agent. Like, these are legalese terms. We're reading them. The jury never, when they were sitting in that box, they never heard this stuff coming from the bench or coming from the lawyers because it was not made into an issue. The judge said no to the instructions. And if the Court of Appeals judges look at this stuff and they go, look, they should have known. They should have been told this stuff, a new trial will be ordered on maybe that one little issue alone to determine whether or not Waldman was in fact an agent, and the jury to be more properly and accurately instructed. So don't freak out. It doesn't mean like another, 6, 7, 8 week trial or anything crazy. It may just be like a few days. Sometimes Court of Appeals judges will say, look, just decide on this one little issue alone. And that will be able to correct it, and the rest is history. Like, you don't have to relitigate everything from the beginning. Okay? So don't freak out. And I'm not saying they're going to do that either. I'm just saying that is one possibility. So all this argument about agency and principal liability and vicarious liability, it's all cute. And it's all very, very good. And they're making great arguments. I'm not going to lie. This is like the first brief that I'm reading, and I'm like, finally, for the most part, even though the first third was again abuse, the judges don't fucking care. They don't care. They want to focus on the main meat. And the meat is agency. Give me agency. Fuck all the other shit. We don't care. We're Court of Appeals judges. We determine cases based on the law, not facts and emotion. And they're shoving that fact and an emotion in the judges' faces again, and it's completely unnecessary. Completely unnecessary. It detracts from the argument, it detracts from the brief, it detracts from your professionalism, it confuses the hell out of the judges because they're probably skimming through trying to find where you're actually making sense of so basically tell them, start reading on page 15. That's where you're really gonna get the stuff. Everything else is garbage, which it is. It really is. It doesn't even matter what those facts are. They don't do anything to serve the appellant in this case. It just doesn't make any sense. It doesn't make any sense. So, take it with a grain of salt. All right. Argument numero dos. Argument number 2. Ms. Heard presented sufficient evidence of actual malice. Because this was one of the other arguments that Johnny made. This is 1B. There was insufficient evidence to show actual malice by Waldman when he came out and made the statement that this was all a hoax, right? And they're saying, oh, yes, there was enough. Oh, yes, there was. A, Mr. Depp waived any argument that summary judgment should have been granted. In the section of his opening brief regarding actual malice, Mr. Depp asserts the circuit court erred in denying Mr. Depp's motion for summary judgment and motion to strike. Despite this statement, he has presented no argument concerning the summary judgment record and relies exclusively on the evidence presented at trial. The conclusion of this section suggests Mr. Depp seeks to abandon any error regarding summary judgment by omitting any reference to this motion and stating only that the motion to strike should have been granted. Rule 5A20E requires appellant's opening brief to include argument, including principles of law and authorities relating to each assignment of error. At the risk of stating the obvious, the rules of the Supreme Court are rules, not suggestions. Thank you, Captain Obvious. We expect litigants before this court to abide by them. Failure to adequately develop an argument on the brief is colloquially called a bad brief waiver. Lack of an adequate argument on brief in support of an assignment of error constitutes a waiver of that issue. By the way, let me just make a quick reminder. We have special merch. You all may see it is pinned right here. This is a new YouTube feature. I haven't mentioned it in a hot minute, so let me just take a moment. I'm wearing one of those. You Lost here have a Mega Pint shirts. They're available right down below. And there's also a link in the description if you're in the replay crew. So hello again to the replay crew. And let's get back to the show. Lack of an adequate argument on brief in support of an assignment of error constitutes a waiver on that issue. The opening brief contains no argument and no authority supporting Mr. Depp's contention that his motion for summary judgment should have been granted because Ms. Heard cannot prove malice. He has thus waived any error arising from the denial of that motion. In any event, the circuit court properly denied summary judgment. By the way, this is basically them saying you do not have to even go to this. You do not even have to go to this at all. The only downside, and this is why it's kind of buried in the middle, it's kind of squished in the middle, is because the court doesn't even need to address this. If they're going to determine that the jury got it wrong, again, actual malice doesn't even matter. So whether it's there or it's not there, it doesn't matter. So this is kind of like a by the way argument that they're making, an argument number 2. In any event, the circuit court properly denied summary judgment. The decision to grant a motion for summary judgment is a drastic remedy which is available only when there are no material facts genuinely in dispute. A grant of summary judgment must be based upon undisputed facts established by pleadings, admissions in the pleadings, and admissions made in answers to requests for admissions. All true. In reviewing a ruling on a motion for summary judgment, the court views the record in the light most favorable to the non-moving party. In this case, of course, it is Amber. In Mr. Depp's memorandum supporting his motion for summary judgment, his sole basis for arguing Ms. Heard could not prove actual malice was an interrogatory response he described as factually empty. According to Mr. Depp, this interrogatory requested that Ms. Heard explain how Mr. Depp can be held legally responsible for Mr. Waldman's conduct. Ms. Heard had no burden to develop the record at summary judgment. There's a case that granted summary judgment based on discovery depositions was reversible error because the plaintiff was under no duty to fully develop her allegations of negligence during discovery. Rather, Mr. Depp, as the moving party, had the burden of proving no material fact was genuinely in dispute. That's what the law says. As such, any deficiency in Ms. Heard's interrogatory responses was a discovery matter which did not warrant granting summary judgment, which was not granted. So, thank you. Standard of review. Ordinarily, when reviewing a circuit court's ruling on a motion to strike, the court determines whether the evidence presented at trial, taken in the light most favorable to the prevailing party, was sufficient to support a jury's verdict. Same standard as before. Because Ms. Heard is a public figure, she was required to prove the statement was made with actual malice, that is, with knowledge that it was false or with reckless disregard of whether it was false or not. Quoting New York Times, as you all know, this is our famous case about malice, actual malice, providing immunity for defamation based on statements regarding matters of public concern that are protected by the First Amendment and published without actual malice. Whether the evidence in the record in a defamation case is sufficient to support a finding of actual malice is a question of law for the court. Appellate courts have a constitutional duty to exercise independent judgment and determine whether the record establishes actual malice with convincing clarity. This rule of independent review assigns to judges a constitutional responsibility that cannot be delegated to the trier of fact, in this case, the jury. Taken together, these standards of review require the court to view the evidence in light most favorable to Ms. Heard when examining the record of evidence of actual malice. That's the standard. Ms. Heard could prove defamation by showing either Mr. Depp or Mr. Waldman had actual malice. So it doesn't even matter we're saying which one did it with actual malice. Either one is sufficient, or both. There are actually three distinct bases, is what they're arguing, on which the common law of agency attributes the legal consequences of one person's actions to another. Actual authority, apparent authority, and respondeat superior, also known as vicarious liability. This comes from the Restatement Third of Agency. Some note in there. A principal is subject to direct liability for an agent's tortious conduct that occurs with the scope of his actual authority, while vicarious liability arises from respondeat superior or a tort committed with apparent authority. Contrary to Mr. Depp's contention, Ms. Heard did not rely exclusively on a theory of vicarious liability by maintaining that Mr. Waldman made the statement while acting as an agent. This is because a principal's liability for the acts of an agent is not confined to theories of vicarious liability, as we just saw, actual authority or implied authority, or vicarious liability. Ms. Heard was free to argue liability arose because Mr. Waldman was acting within the scope of his authority when he made the statement. Indeed, she tendered, and the circuit court gave, a jury instruction titled Express and Implied Authority, which provided an attorney has the express authority to do everything which the client expressly authorized them to do, and the implied authority to do necessary or incidental for the purpose for which he was retained, or she, in this case he. As previously explained, a fact finder could have concluded that for the purposes for which Mr. Waldman was retained included speaking to the press on Mr. Depp's behalf or generating negative publicity about Ms. Heard. A principal's liability for the acts of an agent is not contingent upon the agent's liability. For example, a principal is subject to liability to a third party harmed by an agent's conduct when the agent's conduct is within the scope of the agent's actual authority or ratified by the principal, and the agent's conduct is tortious, or the agent's conduct, if that of the principal, would subject the principal to tort liability. One of the reasons principal's liability can be independent of an agent's liability is an agent's action may not be tortious because the agent lacks information known to the principal. Otherwise, a principal could hire an agent to make false statements and avoid liability for defamation as long as the agent lacked actual malice when publishing the statements. So basically, you can have a workaround theory, right? I just hire somebody and now I'm not liable. Doesn't really work. That's the argument. As Section 704 makes clear, Ms. Heard could prove defamation by showing either Mr. Depp or Mr. Waldman had actual malice when the statement was published. Under Section 704A, or 704.1, excuse me, Mr. Waldman's conduct is tortious and imputed to Mr. Depp if he published the statement with actual malice. And under Section 704.2, the inquiry is whether liability for defamation would arise if Mr. Depp published a statement, thereby permitting Ms. Heard to rely on Mr. Depp's actual malice to prove defamation. Here, evidence established that both Mr. Depp and Mr. Waldman had actual malice is their argument. And let's look at each one in turn. Number one, Mr. Depp had actual malice. As the perpetrator of domestic violence, you do realize that actual malice has nothing to do with like malicious intent, right? Actual malice is a legal term. So now now I understand why they used the fact scenario earlier on. Now it makes a lot of sense. Okay, all right, let's get through this. As the perpetrator of domestic violence on May 21st, 2016, Mr. Depp is aware that he abused Ms. Heard physically, verbally, emotionally that evening. For that reason, he knows the assertion that there was an ambush, hoax, or setup is false. Again, subject to very, very, very serious debate and very serious dispute, as the trial has already shown. This is a clear misstatement of fact, you guys. Yes, it's found in the record, but that's not the point. The point is, this is easily debunked. This is absolutely easily debunked because it has already been shown the complete opposite in the trial. That's pretty insane that they're actually misstating the facts. At the time, they were facts. Now that they've been debunked, to risk your law license on a brief, on one case, you're putting your entire career on the line, and then what are you going to do? Argue that, oh, I'm sorry, I didn't know? I don't know. That seems a little extreme. Mitch West, thank you, says, hello, Larry. If Turd, I think you're referring to Amber, wins her $2 million, does JD have to pay her up before he gets his $8.35 million? It's a great question. And it depends on how the appeal plays out. It's not answerable at this juncture. Mr. Depp had actual malice. So, okay. He also knows that Ms. Heard and her friends did not spill the wine. And again, this is all subject to speculation. And the brief is not a place for speculation. Again, this is starting to reek how they're tying it together. Up until this point, it was good, but now you just took a turn on shit street, and you took a left, and now you got shit on your tires. Not a good look. Not a good look for a brief. He also knows that Ms. Heard and her friends did not spill wine or rough up the penthouses because he caused the property damage to the penthouses and spilled wine there on May 21st, 2016. Consequently, there is ample evidence from which the jury could infer that Mr. Depp knew the statement was false or was reckless with respect to its falsity. Mr. Waldman had actual malice. Mr. Waldman testified he had no first-hand knowledge of whether Mr. Depp abused Ms. Heard, but claimed he saw some things that show her statements to be false. When describing these things with respect to May 21st, 2016, Mr. Waldman testified, so there are two police officers, one domestic violence-trained female cop who testified over and over and over that there was no damage to the penthouse, which Ms. Heard claimed was destroyed. That's a direct quote, destroyed, emphasis added. Based on this testimony, a fact finder could have concluded Mr. Waldman believed there was no damage to the penthouses on May 21st, 2016. This conclusion would have been supported by the testimony of 3 law enforcement officers who responded to calls to investigate domestic violence at the penthouses. All 3 officers, all 3 officers saw no damage. Try saying that 10 times. To the penthouses, and the jury could have inferred that Mr. Waldman spoke to these officers or reviewed their testimony when reaching his conclusion that there was no damage to the penthouses at any point on the evening of May 21st, 2016. Yet, Mr. Waldman told the Daily Mail there was no damage, Yet, Mr. Waldman told the Daily Mail there was damage to the penthouses. He asserted in the statement, Amber and her friends spilled a little wine, roughed the place up. Mr. Waldman could not logically believe both that there was no damage and that Ms. Heard damaged the property to fabricate the evidence of domestic violence. I think what they're implying is that Depp said there was no damage done by him. But I could be wrong. The jury could have found that Mr. Waldman's testimony contradicted his belief in the truth of the statement, thereby demonstrating that he knew it was false or was reckless with respect to its falsity. In addition, when making the statement and others as Mr. Depp's attack dog, oof, oh, come on, man. See, it's words like this that make me question. You don't want to raise the judge's ire by being an asshole. It's anytime you have a potential to raise eyebrows, you don't want to do that in an appeal brief. In addition, when making the statement and others as Mr. Depp's attack dog, I was with you, following your argument until this, and when I see that, I'm like, dude, come on. That is such a completely unnecessary statement in a legal brief. You can make that in a cross-examination. I mean, this really sounds like Rottenborn, doesn't it? Did I read that right, Mr. Depp? Did I read that right? It's the same thing. It's when you were Mr. Depp's attack dog. Dude. It works for a jury. It does not work with a court of appeals panel of judges. They don't care about your little baby drama that you're trying to create. This is not the place for it. This is not the time for it. This is an incorrect platform to raise your bullshit arguments, okay? Come on, man. Get your shit together. In addition, when making the statement and others as Mr. Depp's attack dog, and when he filed a police report for perjury simply so he could tell the press falsely that Ms. Heard was being investigated for perjury, Mr. Waldman selectively credited only the evidence that he believed was favorable to Mr. Depp and ignored the abundant evidence of Mr. Depp's abuse of Ms. Heard, which doesn't exist. But okay, including the evidence regarding the night of May 21st, 2016. Therefore, a jury could have reasonably concluded that he neither knew the statement was false, either knew his statement was false, or was reckless in not knowing and thus possessed actual malice. That whole argument is just no. Argument number 2, if I were you, I would have removed entirely. I would have removed. Maybe you did it just to fill up some space. When in doubt, don't include. That's the rule of appeal brief writing. When in doubt, don't just be like, I have 50 pages, but I only have 36 pages of content. Let's just throw this argument in for good measure and fill up the remaining 14 pages that we have. If it detracts from your argument, if it detracts from your veracity, if it detracts from your potential of looking as not very truthful to the tribunal, especially, you don't want to include that. You're just shooting yourself in the foot. You're like, you made this great argument in your first one, and then you took the second one, which almost in my head kind of unraveled your entire first argument. You know what I mean? I just don't understand. I don't understand why you would do this to yourself. But okay. It's made. It's filed. It's in the record. Don't forget to like this video, comment below, subscribe to the channel, join on as a member, and don't forget, we got merch. We got merch for days. You lost. Amber. You lost. Here. Have a mega pint. Oh wait, I'm not full screen. There we go. You lost, Amber. Here. Have a mega pint. With Johnny's face on it. Holding the chalice. Isn't that cool? Thank you, YouTube, by the way. They designed it. Check it out. There's Johnny's face on there. You can have it on a t-shirt. You can have it on a pint mug or a pint glass. You can have it on a mug. Pick your poison. Pick your choice. Super cool. Thank you, YouTube. Somebody said take it off. You want a kitty break? We can do a quick kitty break. Where is she? Oh, she's sleeping. I don't know. I don't want to disturb her. She's sleeping. Maybe later. Maybe later. Maybe later. When she disturbs me next time, that's when I'm gonna go. All right. Back to the brief. Argument number 3. The statement is actionable because it contains a provably false factual connotation. This is relating to assignment of error 1C of Johnny Depp, relating to the Depp-Waldman statement. The standard of review. Whether an alleged defamatory statement is one of fact or opinion is a question of law reviewed de novo. So again, de novo review. De nuevo, anew. In conducting its review, the court does not determine whether the alleged defamatory statement is true or false, but whether it is capable of being proved true or false. The statement is not protected speech. While pure expressions of opinion are constitutionally protected and cannot form the basis of a defamation action, there is no wholesale defamation exemption for anything that might be labeled opinion. Expressions of opinion may often imply an assertion of objective fact, and simply couching statements in terms of opinion does not dispel these implications. Factual statements made to support or justify an opinion can also form the basis of a defamation action. The test for distinguishing pure expressions, this is all outlining what the law is. The test for distinguishing a pure expressions of opinion from actionable factual assertions, there we go, is whether the statement contains a provably false factual connotation and is thus capable of being proven true or false. That's the test. That's the test. Statements that doctors abandoned their patients and that there were concerns about their competence were falsifiable. Statements that a doctor was engaged in excessive billing, sought reimbursement for services that were not authorized or performed, and was opportunistic and aggressive about pursuing money or assertions of fact. For another example, these are all Virginia cases. The statement that plaintiff takes people's money is capable of disproof by evidence. If adduced, the plaintiff's clients received monetary or other relief as a result of his legal services. The statement, which clearly contains a provably false connotation, reads as follows. Thank you, Lacey Tawiyaka. She says, doesn't surprise me as I've seen how unprofessional they are. If I see one more site to Wikipedia, then they probably changed that website themselves. Well, I wouldn't go that far. I know Wiki can be edited fairly easily, but at the end of the day, I see where you're going. Absolutely see where you're going with that. It's a valid point. So the statement, quite simply, was an ambush, a hoax. They set him up. Calling the cops first didn't do the trick. The officers came to the penthouse, thoroughly searched, interviewed, left after seeing no damage to face her property. So Amber and her friends spilled a little wine, roughed it up, got their story straight, talked to a lawyer, publicist, and then placed a second call. This is like the third time we see this statement in the brief. You don't need to do that. You already said it's going to be the statement. Why do you keep doing this? This is the third time you're putting it in there. Completely unnecessary. Appeal to emotion, no place for a brief. This is not what you do in a brief. The assertions in this statement are capable of being proven false, with evidence that Ms. Heard and her friends did not call law enforcement on May 21st, 2016, spill wine, rough up the couple's home, fabricate evidence of domestic violence, or contact a lawyer or publicist. Evidence could also be presented to demonstrate the officers who responded saw Ms. Heard's injuries and property damage, but did not conduct a thorough search. The contention that Ms. Heard carried out an ambush or hoax is falsifiable because Ms. Heard can and did prove. Did she though? Okay. This is what you're going with, Ben. This is what you're sticking to. And did prove Mr. Depp abused her on May 21st, 2016. Subject to dispute, but okay. To the extent these phrases are opinions, they are nonetheless actionable because the remainder of the statement sets forth a factual basis that supports these assertions. Factual statements made to support or justify an opinion are actionable. Mr. Depp does not challenge that the statement contains a provably false factual connotation. So why are you arguing it in the first place? Just end the argument here. Instead, he maintains that the context of the statement transforms it into an opinion. When determining whether a statement is actionable, courts examine the statement in context by applying the general rule that words are to be taken in their plain and natural meaning and to be understood by courts and juries as other people would understand them, and according to the sense in which they appear to have been used. Here, the statement makes objective assertions about the events of May 21st, 2021. The only plain and natural meaning a person would draw from the statement is that these events in fact occurred. Relying on this case, Mr. Depp contends that a reader would understand the statement as Mr. Waldman speaking as a legal advocate and offering his own interpretation of disputed evidence. In Riley, the First Circuit observed that even a provably false statement is not actionable if it is plain that the speaker is expressing a subjective view, an interpretation, a theory, conjecture, or surmise, rather than claiming to be in possession of objectively verifiable facts. While no Virginia court has ever adopted this principle, it applies only where an author outlines the facts available to him or her, thus making it clear that the challenge statement represents his own or her own interpretation of those facts, and leaving the reader free to draw his or her own conclusions. Mr. Waldman did not outline the facts available to him in the statement, although the article notes that Mr. Depp's legal team pointed out the 911 caller on May 21st, 2016, had a female voice, and the Los Angeles Police Department registered Mr. Wright's call at 10:09. This explains at most why Mr. Waldman asserted 2 911 calls were made in the state. So now you're speculating as to what Mr. Waldman is saying? Oh, come on, man. There's no explanation of fact that would be interpreted as supporting the defamatory assertion that Ms. Heard set up Mr. Depp by fabricating evidence of domestic violence. Again, I think this has already been addressed, and they're just trying to... Ben Rottenborn is trying to rewrite history, it seems like. He's trying to rewrite the facts. He's trying to rewrite what happened in the case, and it's very disappointing. A lot of these parts appear to be more PR moves. This is going to show up in more little purple blobs with Amber's face looking all innocent and going, oh, poor dear me, and citing this brief like, this is what happened, and da-da-da. They love doing this shit. They love using this as PR fodder. It's not effective legal argument. It's just PR fodder for trying to restore her reputation. That's never going to happen, but at least to try in the eyes of people who have not seen the case and just heard about it. Pixie Doll says, so we're too stupid to know AH was talking about JD in op-ed, but we are smart to know AW was talking for JD. Pick a side, Mr. Rottenborn. I love the sass. I love the sass. Okay. Mr. Depp also asserts that courts consider factors such as whether the form in which the statement is made would cause a reader to understand it as the author's opinion, the degree to which the audience is familiar with the underlying facts, very true, and the identity of the speaker. You should cite to a case here. That's very important stuff. But there's no cite. Each of these factors suggests the statement is not an opinion. The Forum is the Daily Mail, a widely circulated tabloid that publishes newsworthy accounts of factual events, not opinion pieces. The overwhelming majority of the Daily Mail's numerous readers are not familiar with the underlying facts of Ms. Heard's abuse at the time of the publication. And the identity of the speaker, as Mr. Depp's attorney suggests, he has inside knowledge or access to evidence that establishes Ms. Heard's allegations are false. While a reader might consider statements an attorney makes in court as mere advocacy, the press is not the traditional forum in which attorneys advocate for their clients, which is true. In sum, in the context of the statement does not transform its factual assertions into opinions. For this reason, the circuit court correctly denied the motion for summary judgment and motions to strike the evidence. And again, I think I've said it before and I'm going to say it again. This was argument number 3. It does have merit. It does have merit, but it's not a central piece. It can still be an actionable defamatory statement, not an opinion. Sure. It's very difficult to turn it into an opinion, I will say that, because it's not easily verifiable. You can't just be like, well, show me, like, you know, this, if the statement was made in coincidence with, let's say, like a video of the events that night, you know, that would be easy. This is not easily verifiable, and it doesn't have the merits of an opinion. So I will agree that it is probably an potentially actionable defamatory statement. Finally, Rottenborn gets at least one right. I agree. I think it's not easily disprovable based on available evidence, especially at the time that it was published. So, but that's still not enough. You got to remember, that's still not enough. And on appeal, if the jury did not have enough information to make a determination as to whether or not it was a false statement and defamatorily actionable statement made with actual malice, well, then the Court of Appeals can still reverse. So this is not the end. This is not the end. Even though it may be a good argument, doesn't mean that Amber automatically wins. But for the first time, I see something of value coming from Rottenborn. And I don't know why it's buried in argument number 3. I would have made it argument number 1. Personally. But that's just me. So, well, JK says, I don't think they established actual malice. Well, the jury thought so, with respect to that one statement. So, but it's going to be up to the courts. No, it's up to the courts. Don't forget to like this video, comment below, subscribe to the channel. Join in as a member. I think we can almost get our new emoji. I think we might already be there. I'll have to check after the stream. But what do you guys want? You guys want an Amy Goodhart emoji? Like, what other options do we have? Or do we even want any options? It's just Amy Goodhart, period, the end. I'm happy to do that. We can do an Amy Goodhart emoji. She definitely deserves one. She's a fucking star and a trooper. Argument number 4. The circuit court correctly rejected the proposed jury instructions. This is it. This is the one that if Johnny wins, he only needs to win on this. Everything else is negligible, honestly, in my opinion. Because if the jury was not properly informed of how they're supposed to make a determination as to whether or not Depp's liability is accounted for in Waldman's statements, well, then you'll have to have a retrial on that one issue. Standard of review. The decision to deny a jury instruction rests with the discretion of the trial court and will not be reversed absent an abuse of discretion. This is the abuse of discretion standard. Up until this point, it was all de novo, de novo, de novo. For the first time, we now have an abuse of discretion standard. The sole purpose of appellate review of jury instructions is to see that the law has been clearly stated and that the instructions cover all issues which the evidence fairly raises. Whether the content of the instruction is an accurate statement of the relevant legal principles is a question of law that, like all questions of law, is reviewed de novo. Excuse me. Where other instructions fully and fairly cover the principles of law governing the case, the trial court does not err in refusing an additional instruction on the same subject. So when you have enough instructions that explain everything the jury needs to know, butt out, the rest doesn't matter, basically. B of argument number 4. The jury instructions fully and fairly covered principles of agency. As previously explained, and I highly disagree here. I highly disagree because the jury was not explained the definitions of a lot of the agent master principles. Let's see what they say. As previously explained, the concept of an independent contractor does not apply to this case because Mr. Depp's liability stems from Mr. Waldman's role as his agent when speaking to the press. And even if Mr. Waldman is an independent contractor, it still doesn't preclude Mr. Depp's liability for his conduct. Therefore, proposed jury instructions 22, 23, 24, which concern independent contractors, are not accurate statements of the relevant legal principles and were correctly refused. And this is my whole point of disagreement with their argument. Because, look, at the end of the day, jurors have to make an informed decision. If you don't give them enough tools and information that comes from the bench as to how to grind all these facts that they've been getting for all these weeks, and especially with the misleading weasel phrase by Ben Rottenborn in closing argument and during cross-examination of Depp, and I believe even direct of Amber, the Depp-Waldman statement, Depp-Waldman statement, Depp-Waldman statement, Depp-Waldman statement. He literally just grinded and force-fed the jury this fact that it's the same person. The statement was basically made by the two of them, which is not true. It's not the case. Danny G says, could BS firm have dropped, Ballard Spar firm dropped AH? If they realize it's a dumpster fire, they wouldn't win, and especially because it could cause them permanent reputational harm. It's possible. I don't know, Danny G. I don't have the facts. Is Amber still in Spain, by the way? Does anybody know? I don't know where Amber is these days. I heard rumors that she moved out. I heard rumors that her place was raided. I heard rumors that some more stuff happened. I don't know. I don't know anything. Ain't nobody telling me nothing, you guys. Ain't nobody telling me nothing. How does a lawyer argue, says just another rando, how does a lawyer argue that a lawyer is an agent and says that their client didn't do is defamation? That's dangerous precedent, or no? Potentially just another rando. That is potentially setting a dangerous precedent, but the question is, the judges are always going to look at case law that is already established and kind of go off of that. That's called the doctrine of, what's the legal term? It's escaping me. You're taking me all the way back to law school, so you have to excuse me. It's precedent. I don't remember the Latin term. I can't remember off the top of my head right now. But basically, that's exactly what it is. That's exactly what it is. Judges are there in order to create good law. And they're going to be basing that on old law that is already established. That's literally how our legal system works. Otherwise, if every judge was like, all right, I'm going to create this law, and then it's going to run in contradiction to like everything else, we would have a host of problems. A host of problems. All right. So, accurate statements of the relevant legal principles. So they're saying these are legal principles, but instructions 22, 23, 24 are not relevant. We don't care. Move along. Additionally, the refused jury instructions on independent contractors overlap with the given instruction on agency. Jury instruction TT defined a principal agent. A principal is a person or legal entity with power or right to control the means and methods of performance by which another person performs the principal's work. An agent is the person who is subject to the power or right of a principal to control the means and methods of performing the work. Proposed jury instruction number 22 effectively defined an independent contractor as the opposite of an agent. An independent contractor is a person who is engaged to produce a specific result, but who is not subject to the control of the employer principal as to the way he brings about that result, or she. If you find that Mr. Waldman was acting on Mr. Depp's behalf, but was not subject to Mr. Depp's control as to the manner, method, and or means by which Mr. Waldman worked, you must find that Mr. Waldman was an independent contractor. Both instruction TT and proposed jury instruction number 22 explain that liability depends on whether Mr. Waldman was subject to Mr. Depp's control with respect to the means and methods of his work. In light of this redundancy, the Circuit Court did not abuse its discretion by refusing proposed instruction number 22. Courts may refuse additional instruction on the same subject as given instructions. Again, I disagree. I think it gives a broader stroke, but that's the argument that they're making. Moreover, Mr. Depp suffered no prejudice due to the refusal of proposed jury instruction number 22 because he was free to argue that, based on jury instruction TT, he was not liable because Mr. Waldman was not his agent. See code such and such, prohibiting reversal for harmless error, and a mistake of law made during a trial process is harmless error unless it prejudiced the appellant. Proposed instruction number 24 is duplicative with the given instruction on the burden of proof. Jury instruction 20 already provided. Ms. Heard has the burden of providing, by the greater weight of the evidence, that Mr. Waldman was an agent of Mr. Depp and that Mr. Waldman was acting within the scope of his agency when he made the statements. Explaining the jury should return a verdict in favor of Ms. Heard if she proved Mr. Waldman was acting as an agent when he made the statement. Proposed jury instruction number 24 says, a person who hires an independent contractor is not liable for the independent contractor's actions. If you find that Mr. Waldman was an independent contractor of Mr. Depp instead of an employee, you may not find that Mr. Depp liable for Mr. Waldman's conduct. The jury instruction on the burden of proof adequately explained that Mr. Depp's liability turned on proof of agency. Giving an additional instruction providing Mr. Depp was not liable if Mr. Waldman was an independent contractor, defined as the opposite of an agent, would have been duplicative and unnecessary, they say, noting it is not desirable to multiply instructions, and finding duplicative instruction was properly refused. Proposed instruction number 24 also expresses the same false dichotomy discussed above by asserting that the jury may find Mr. Waldman is an independent contractor instead of an employee. This assertion would have confused the jury by indicating Ms. Heard was required to show Mr. Waldman was Mr. Depp's employee rather than his agent. Courts should not give confusing jury instructions, they argue. Finally, the Circuit Court did not abuse its discretion by refusing proposed jury instruction number 23 because giving it would have invaded the province of the jury. It is fundamental that the court must respond to questions of law and the jury to questions of fact. Whether a person is an employee or an independent contractor is a question of fact for the jury. Yet, proposed instruction number 23 stated, an outside lawyer retained by a client in connection with litigation is an independent contractor. This instruction would have directed the jury to, basically it's a conclusion, not improper instruction. This instruction would have directed the jury to automatically conclude that Mr. Waldman was an independent contractor, thereby usurping the jury's role to decide this question as a matter of fact based on the evidence presented. At a minimum, this instruction would have improperly singled out for emphasis a part of the evidence tending to establish a particular fact by highlighting Mr. Waldman's role as an attorney. Argumentative jury instructions should be refused. Nicholas Stero says, still don't get how a statement at the bottom of a page of a British tabloid with virtually no circulation in the U.S. can be worth $2 million. Mitch West says, if only JD could bring in the Turd's former lawyer as an agent for writing defamatory book. Right. Man. Um, that was a whole lot of nothing, in my opinion. I mean, just circling back and forth about. They have to address it. They have to address it. Otherwise, they waive the issue and Johnny will automatically win. It's just so hard to square away that these instructions, I feel, complement and add to the other. And again, I understand this is literally me siding with Camille and Ben Chu. I get it. Larry, your bias is showing. Well, no shit. That's not the point. The point is I'm looking at the merits of the legal argument. And they look decent. That the jury instructions failure to include the definition sections of the instructions 22. 23 is a little shaky. I will give them that. 23 is a little shaky. But 22 and 24 seem to kind of bridge the gap for the jury because jurors are just people. They're just human beings with basic understanding of the law. Nothing too comprehensive. And this is really, really, really complex stuff. Even I don't get some of it. I have to literally read and just kind of like delve into to fully comprehend the arguments that are trying to make. I'm not a First Amendment lawyer. You all know this. I'm starting to become an expert on First Amendment law thanks to all these briefs. But at the end of the day, there's just so much missing for the jury that I feel the Court of Appeals may, if they reverse, because they may just say, look, it all stands as is, and Johnny will lose his appeal, which he doesn't even care. I get it. But even if they don't have to find true or false on every single one of these, all they have to do is say one thing, like, look, the jury should have been informed, for example. Or Waldman, it doesn't make sense how they squared away that Waldman was an agent when there was insufficient evidence to show that he was an agent. Or they may say, yes, there is sufficient evidence to show that he was an agent, so we don't need to go into that at length or deeply. So it could go so many different ways, but the bottom line, I guess at the end of the day, what really gives me personally comfort is it doesn't matter. Win or lose, this portion of the appeal really doesn't matter. I think the strongest argument is the jury instructions. Judges, this is why, okay? I'll explain my position because people are going to ask, well, he made all these other arguments. Why are you considering those? I'll tell you why. Because judges are, when they're confronted with two different issues, okay, let's break it down into the simplest of its constituent parts. You have very, very, very complicated, complex agent, master-servant arguments here that may or may not have merit. And then on this side, you have all these arguments that are very direct and simple and don't require an entire revisiting and explanation of the law and setting new precedent for future generations. Judges will always pick the road that does not require getting a machete and chopping down an entire jungle. If there is a road that is already paved, they're going to do that instead of, demolishing the jungle. They're just going to say, look, the easiest answer is usually going to be the first one picked by judges. Judges do not like to create complex or to rely on complex theories when the easiest answer is possibly the correct one. So, I don't know. Judges are not strangers to changing the law, of course, but they also don't like to do so when there is a viable alternative to that. And there certainly is here. There absolutely is a viable alternative here. Number 5. Argument number 5. The circuit court did not abuse its discretion by requiring redaction of irrelevant and inadmissible portions of the article containing the statement. This is when they took the big article, they redacted, remember all the black pieces, they just left Waldman's statements in the article, which took away context, but also got rid of additional irrelevant information for the jury. This was Amber's argument. Johnny's argument is, well, they lost the context, and that was important for them to make a determination whether or not those statements were in fact defamatory or not. Okay? Standard of review, as always. This time, abuse of discretion. Decisions regarding the admissibility of evidence lie within the trial court's sound discretion and will not be disturbed on appeal absent an abuse of discretion. A court has abused its discretion if its decision was affected by an error of law or was one with which no reasonable jurist could agree. We haven't found any typographical errors in like 20 pages. Slow clap to you, Rottenborn. 4 mistakes so far is enough, huh? The redacted portions of the article were inadmissible. The circuit court properly excluded the contents of the full article that contained the statements because it constituted inadmissible hearsay and was not necessary for the jury to assess whether the statement was defamatory. For the purposes of the third restatement of error, the court need focus only on the statement that the jury found was defamatory towards Heard. Mr. Depp challenges the circuit court's redaction of all 3 articles that form the basis of the counterclaim. Although Ms. Heard disagrees with the jury's verdict on the other 2 statements, Mr. Depp made through Mr. Waldman that comprise her counterclaim and does not believe such a verdict was supported by the evidence, the jury did not find these statements to be defamatory, and therefore any error relating to the exclusion of the full articles in which these statements appeared is harmless and irrelevant. This is one sentence from although to relevant. 1, 2, 3, 4, 5, 6 lines, 5 lines. You need to break it up, man. That is a mouthful. Mr. Depp argues that the full text of the article was necessary for the jury because it would have shown the statement was not an actionable defamatory comment. As explained above in Section 3, the statement was plainly defamatory and was not protected speech. Moreover, Mr. Depp presents no argument or evidence other than his own conjecture that anyone reading the article would have understood the statement as anything other than a statement of fact that Ms. Heard and her friends lied about Mr. Depp's physical abuse and property damage on May 21st, 2016. The fact that the article contained a quote from Ms. Heard's lawyers, additional statements by Mr. Waldman on behalf of Mr. Depp that were factual in nature and references to the parties' ongoing dispute does not and cannot remove the defamatory sting of the statement. As the circuit court noted, whether or not the statement is defamatory cannot depend on the third party's decision to put the statement in a certain portion of a certain article. That is because, as the circuit court correctly ruled at the time that the statement was made, Mr. Waldman didn't know that what the articles were going to say or how they were going to print the article. This ruling was not abuse of discretion, so they argue. Trial courts will have to decide on a case-by-case basis whether an unredacted document containing both actionable statements of fact and statements of mere opinion should be presented to the jury for purposes of providing context for the actionable statements of fact. This is why it's an abuse of discretion standard, that the judge did not abuse her discretion by saying this is in, this is out. Or whether only the actionable statements of fact should be presented for the jury's consideration. Mr. Depp's reliance on this case from Virginia is misplaced. Contrary to Mr. Depp's interpretation, this case simply stands for the proposition that a court may consider the alleged defamatory comment in the context of a longer statement by the same defendant for the purposes of determining whether a statement can be reasonably understood as stating or implying actual facts, whether those statements are verifiable, and whether they are reasonably capable of defamatory meaning. These are all questions of law for a court, not factual questions for the jury. In that case, the Supreme Court considered the defendant's full emails because, read in the context with all the words from the same defendant, the alleged defamatory statements did not contain sufficient defamatory sting or constituted protected opinion. Mr. Depp cites no case that takes the stance He now asked the court to adopt that the defamatory nature of one person's statement quoted in an article may somehow be cleansed by the statements of others quoted in the same article or statements of the author of the article itself. The circuit court properly excluded this other commentary because it was inadmissible hearsay and because it was not relevant to the jury's inquiry. This includes the additional statement from Mr. Waldman that Ms. Heard and her friends alleged hoax didn't have the desired effect because it does nothing to change the meaning of the defamatory statement. And, unlike the statement in that case that the court found was protected opinion because it was based on facts that themselves were not alleged to be false and defamatory, the statement itself was a factual statement involving Ms. Heard that the jury found to be false. Nothing about the rest of the article could have changed the correct determination by the jury that Mr. Depp's statements through Mr. Waldman in that article met the elements of defamation. Similarly, although Ms. Heard disagrees with the jury's verdict that the other statements Mr. Depp made through Mr. Waldman were not defamatory, the full articles in which these statements appeared have no bearing on whether Mr. Depp is liable for the statement. Finally, Mr. Depp's suggestion that the full articles were necessary for the jury to assess Heard's damages is wrong. The remainder of the article simply discussed fragmented aspects of the ongoing dispute regarding Mr. Depp and Ms. Heard's relationship, and the jury was presented with far more details of the relationship through the evidence permitted at trial, albeit an incomplete picture due to the court's improper exclusion of much of Ms. Heard's evidence of abuse by Mr. Depp. And the jury was presented with evidence of the ways in which Ms. Heard had been damaged by the statement, both from Ms. Heard herself and from dueling damages experts. Thus, to the extent the circuit court erred in excluding the contents of the article that contained the statement, any such error was harmless, noting that a reviewing court must consider the potential effect of the excluded evidence in the light of all the evidence that was presented to the jury. There is nothing that the remainder of the articles could have added to the evidence regarding damages that was presented to the jury. So, again, this one is a backup argument. Whenever you make arguments on appeal, you want to make sure you cover all your bases in case you don't accidentally miss something. This is by far Johnny Depp's weakest argument. That's why it's number 5 in their response as well. Because although I haven't read the full article, I imagine it probably could, because it's not like an email that was drafted by one person, or it's an article drafted by an editor, or by a journalist, and then seen by an editor, and then published by a newspaper, the Daily Mail. So taking the statements out of context is not ideal for the plaintiff, for Johnny, but the problem is getting those other statements in over objections of hearsay is not easy. It's absolutely not easy. And maybe the judge did make the right call. I don't know. Like I said, you don't have to win on every single argument. All you have to do is win once on one thing. And the path of least resistance is usually the best default for judges to fall on, because they don't have to sift through all this legal mumbo jumbo. They just focus on one thing and they go, look, the jury instruction should have been included. It was not. New trial. Go. That's it. That's it. It seems overly simplified because it is. It is overly simplified. When it's simple, it's easy. When it's easy, judges jump on it, because it doesn't require a whole slew. And they may disagree with everything. They may say, look, Johnny, Waldman made it. He was your agent. The jury was informed. Jury made a decision. We're not going to disturb the judgment. Call it a day. Call it a day. Anything is possible. Anything is possible. But so far, I'm not going to lie, despite the 4 grammatical errors, this sadly, is their best piece of work so far. Ben Rottenborn comes in fucking clutch by himself, basically, with one other lawyer, Don't forget to like this video, comment below, subscribe to the channel if you haven't already. Join on as a member and check out the merch. Merch. Yeah. You lost, Amber. Have a mega pants. I'm so fucking goofy. Please ignore me. I'm riding this high of like a 3-hour stream. I don't know. I think the mega pint glass is the best. Like, it's straight up the fucking best. I was trying to get one. I don't have one, but I guess it's about this size. It's about this size. Only it doesn't have ridges. We tried Teespring. God bless you guys. Elizabeth, shout out to you. She tried to get me that mug for the stream, but it just wasn't meant to be. I got the t-shirt, so I can't complain. I'm happy. But the mug is on its way, and it will be here. I will show you guys once it's here. I just didn't have it in time for the stream. So yeah. All they have to do is win once. All Johnny has to do is win once. And there we have it. There's the date. Conclusion. For the foregoing reasons, Ms. Heard respectfully requests that the aspect of the judgment of the circuit court at issue in this appeal be affirmed. Dated December 2nd, which was Friday when this was filed. After hours. Submitted respectfully, Ben Rottenborn. I called him Rotten Bottom for the longest time, not intentionally. I just didn't know his name. And then Elaine McCafferty, not Elaine Bredehoft. Bredehoft is bye-bye. Bredehoft is gone. Counsel for Applee. Here's the certificate. It was submitted. Chu, Vasquez, Dennison, and Mayers of Brown Rudnick received a copy. Counsel further certifies that this brief contains 12,464 words. This is the mandatory certification, excluding those portions permitted, may not exceed 50 pages or 12,300 words. Oh, either. Okay, because I was like, that's greater than this, but yeah. Counsel for the appellee respectfully requests oral argument. And remember, oral argument is not typical. Typically, oral argument is not granted in cases. Sometimes it is. If the judges feel like they need clarification on certain issues. But yeah, there you have it, folks. Georgine Prado, thank you for being a member for 1 month with the Holy Grills. She says, I think it's a she. Is it a she? I think it looks like a she. Hey, Larry, finally caught a live from the Philippines. Wow, welcome. And to thank the person who gifted us WD membership. Enjoying your channel and Curious George readings. Aw, thank you very much. Very much appreciated. If you don't know what they're talking about, I read Curious George. Yesterday was my evil twin, or my good twin. I guess I'm the evil twin, according to him. My evil twin, my good twin, whatever you want to call him, paid us a visit, and he was the one reading the Curious George for us. So if you have missed it, that's definitely one you don't want to miss. And then rumor has it that another certain evil twin will be reading the next Curious George book. But I'm fighting for space. I'm trying to make sure that I am going to be the one reading it, but we may have a fight on our hands. So be on the lookout for that. But yeah, there you have it. There's that's the whole brief. Can you believe it? We made it through in less than 3 hours. Amber is fighting for her life right now. Amber is in a lot of legal troubles with her own insurance companies. She's suing, counter-suing, appealing, counter-appealing, responding to appeals. She's got her hands full. It's no surprise why she's out of the country. She may or may not still be in Mallorca, in Spain. I wouldn't be surprised if she had to move again, if paparazzi's starting to like camp out, Journalists and paparazzi are relentless. They don't give a shit about your privacy. Some of them will violate basic like ethical precepts and just like stalk you, just to get the latest scoop because you never know. Yeah, Kitty is knocked. Kitty is knocked out. I'm sorry, you guys. I don't want to disturb her. She just looks so peaceful. Here, I can show you. I can show you what she looks like, but I will not disturb her. Oh, see, she woke up. She woke up. Hi, Zinni. Say hi to the chat. Does it keeps flipping? There we go. She's like, leave me alone. I was sleeping. Why you do this to me, DUI guy? I am DUI Kitty. I need sleeping for my nap time. Right? Is that what you do? Is that what you do? Yeah. I need sleepy for my nap time. Ah! Stupid phone. Okay, alright. I'm done trying to mess with that. Yeah. So, Joe lost. Here. Have a mega pint. Merch available. Go check it out. Alright. Good times. Good times. Tomorrow. What are we doing tomorrow? I have no idea. We'll figure it out. We'll have some fun tomorrow. And then Wednesday, we have a guest. Jason Goodman, who filed a complaint against Boozy, is going to come on and clarify some things for us. Then Thursday, we have Nick Rekieta. And then, God willing, on Saturday, we may have another special guest. Or maybe later. I think I actually just checked my DMs. He may not be available. But we'll get him on some other time. So, anyway, yeah. Thank you all for joining me. I had a lot of fun. We'll see 2 weeks from now. Johnny is going to file his reply. This is the last document that is going to be filed in this case. Johnny is going to file his reply to Amber's response, and that will be it for this appeal. And then parallel to that, 23rd, right, was when Amber filed her opening brief. So count 30 days right before Christmas, assuming we get it on time, which we may not. I know Ben Chu has already requested an extension. He may or may not get it. He probably will, because Amber already, or he may not even request it anymore. I don't know. Only if they need it. Only if they need it, they're going to request it. And then the next brief after that is going to be Amber's reply to Johnny's response. I know, it gets very confusing, but in essence, we were supposed to have 6 briefs, right? Opening brief on each, response, reply. 1, 2, 3, 2, 4, 6. We also had 2 bonuses. We had 2 amici briefs on behalf of Amber. Johnny did not file any amici briefs. He doesn't fucking need them. He's already won. He's already established that. His reputation is clean. He's moved on. So we're going to have a total of at least 8 briefs, and probably no more than that. Thank God. Are we halfway through? I think we're halfway through. We've got 2 opening briefs, 2 amici briefs. We're more than halfway through. Out of 8, we have 2 opening briefs that we've gone over. We have 2 amici briefs we've gone over, and so far we've got 1 response brief. So we have 1 more response and 2 more replies. So there are 3 more to go. So I wanted to thank you from the bottom of my heart, every single one of you, for joining me. We had a crowd of nearly 2,000 people at one point. I mean, this is unprecedented. Thank you to YouTube for allowing me this opportunity to try out some of their new stuff. The pinned product, the products down below, sending me this beautiful t-shirt that you all can get on my Teespring app. the Mega Pint that hopefully will be here any day, and I will show you guys once I receive it. Until then, I love every single one of you. Thank you all for joining me, and I will see you all tomorrow in my next video. Bye, everybody.